Hi, David.
Hello. I don't think I've met you before, Marie, but I know about you, of course. So lovely to meet you online.
Nice to meet you too. I don't know how the auto captioning will go with my Kiwi accent.
It's a great accent. I'm a Kiwi as well, so
Yeah, Dave, you would say that.
It'll probably counterbalance Jonathan's.
Hello, everyone. Good morning, good afternoon, good evening, and I think good night for those joining from Geneva. I'd like to welcome everyone back to day 2 of our forum on law and COVID-19, strengthening legal preparedness and response for the future. This is a WHO Western Pacific Regional Office event being hosted by the University of Melbourne. I'm Jonathan Lieberman. I'm an Associate Professor in Law and Global Health at the University of Melbourne in the Melbourne Law School and the Melbourne School of Population and Global Health. I know many of you were with us yesterday. We had a fantastic day. We had sessions on public health and emergency laws and on the use of digital technologies. And we're very much looking forward to our 2 sessions today. The first one will be on engaging the whole of the health system in the COVID-19 response to meet surging demand. And then we'll have a session which is about building and mobilising legal capacity for the COVID-19 response and for legal preparedness beyond COVID-19. And then we'll have a closing session where we wrap the forum up and look ahead. A reminder to those who are joining the forum by Zoom, the event is being live streamed on Melbourne Law School's YouTube channel. It's being recorded and will be posted on the university's website soon after it concludes. So we're going to move straight into session 4, engaging the whole of the health system in the COVID-19 response to meet surging demand. Just before I turn to David Clark, who'll be the moderator, I'm going to invite Alyssa Liu from Wipro to talk us through Padlet for today.
Thanks, Jonathan. So I'll do a quick recap of the first day's Padlet submissions, and then I'll share with you the link for the following session and also the final session. Thank you everyone for contributing to the Padlet. Just a reminder to please do that if you want to share your thoughts and reflections with us. We will be using some of these in our final report for the forum, and we would love to feature your reflections on there and quote you there as well. So just very quickly from the the second session on the role of public health and health emergency laws during COVID-19 and opportunities for strengthening, we have some really great reflections from several people. One is from Soo-Yoon Kim from Yonsei University, who shared their thoughts on the limitations and challenges of legal frameworks within the COVID-19 response. The first one is on issues pertaining to information gathering and privacy protection. And the second limitation is on implementing the social distancing policies based on accurate scientific evidence. We have similar reflections from Hajime Akiyama from the University of Tsukuba, who shared perspectives from Japan on the legality of lockdowns and the public trust for the government. And they shared that in Japan, a state of emergency was declared, but did not have much power because it wasn't written into the law. It rather just encouraged people to stay at home, but there were no penalties enforced. And there were only 2 restaurants which did not necessarily comply with the order of closure. Hajime believes that the meaning of a state of emergency in Japanese society was not much of a legal one, but to make people more aware of the severity of the situation. And they also stress that it's important to have public trust in place prior to these health emergencies so that it can facilitate the possibility of a lockdown if it is deemed as necessary. And similar to Soo-Yoon Kim, Hajime also noted that legislation should consider very carefully the scientific evidence behind the necessity of interventions like lockdowns and social distancing policies. Ben Lilly from Wipro mentioned that Dr. Balakama raised a very interesting point concerning the coherence between actions taken by government and by private actors. In some instances, private actors have imposed more restrictive measures, potentially impacting employment, access to services, and so on. Governments have taken very different approaches to this issue, with some providing explicit directions and other leaving space for the private sector. And then on lessons learned, Daryl Barrett, who was the former coordinator of the Health Law and Ethics team, mentioned that the fundamental role of law and health is being highlighted during this COVID-19 era, both internationally and domestically. Future investments in building the capacity of member states in understanding and implementing effective health laws for health system strengthening will be key in preparing for and responding for future emergencies and addressing long-standing inequities in the health system. Hajime, from the earlier colleague, also notes that one important lesson would be to perhaps update the understanding of human rights in this scope. International society tends to focus on civil rights and freedom as human rights, and COVID-19 has made us aware of the significance of public health, which requires the government's involvement, but also the significance of the right to life. So that's on that second session. On the third one, we received less comments, but still very important comments. Hajime noted that Associate Professor Taylor said it was important for the government to show the benefits that citizens get as a result of the use of digital technology, so they're able to weigh that in their minds and decide, and that comparison where the technology is not used will be quite persuasive. And then Dilip from Lao Country Office, WHO, said that the need for public health laws to address the appropriate use of technologies to deal with public health emergencies is important. So that's the recap. I urge you to go onto the links and we'll share them on the chat for sessions 4, 5, for sessions 4 and the closing session for today, and to go on to the links that we shared previously, and just to add your comments to those as well, so that we can add them to the report. They'll be open for the next 24 hours. So even if you missed providing some of the reflections from yesterday, please feel free to go there and do so today. I am now going to share, sorry, one second. I'm going to share the link to today's Padlet. It will be in the Zoom chat, so please click on this. And the password is, again, health law in small letters. I'm going to share my screen. So you should be able to see my screen now. Once you are here, you will be able to see some of the 5 leading questions. Again, for the benefit of those who weren't with us yesterday, these questions are the same ones that we posed to our panelists as they prepared for this forum. To answer any of these questions or provide your thoughts, please click on the plus button here. In the subject, please put in your name. So for example, Elisa Liu, and then comma, your affiliation. And right here, you can write down your text. So I'm just going to put a test here. If you would like to attach any links or documents, you can do so here. And then once you're done, click on publish. And I'll be monitoring this board. I'll be able to see it and approve it, and then it will be live. So I'm available on the chat if you have any questions. I'm looking forward to your responses. Thank you. Over back to you, Jonathan.
Thanks very much, Alyssa. And now I'd like to introduce David Clark, who's Team Leader, Universal Health Coverage and Health Systems Law at WHO Headquarters. Over to you, David.
Thanks so much, Jonathan. Welcome, colleagues. Hope we're in for a great session today. We have a great lineup of speakers. First of all, I'll just introduce myself. So I'm David Clark. I'm actually a New Zealander, so I'm from the Wicklow region. I've been in WHO now for about 6 years. Formerly, I used to do a lot of legal work in the Wicklow region, so it's lovely to be with colleagues and friends from the region. Today, we're going to look at the topic of engaging the whole of the health system in the COVID-19 response to meet surging demand. And what does that mean? So what that means is, for our work at WHO, is thinking about not just the government actors in the health system, but also the private actors. And it also means thinking about the sorts of legal mechanisms and other governance arrangements that we need to employ when we are working with private actors, because these are different from when we're working with the government, when we're trying to work on the response. What we have found at WHO over the course of the response is quite a mixed situation when it comes to the activities of private actors. Some private actors have been quite helpful and supportive of the government's public health objectives when it comes to the response, and some not so. We have seen examples of private sector actors engaging in poor behavior in things like price gouging, limiting access to much needed services for COVID. So this whole COVID situation has raised the importance in our minds of looking at how you can govern the whole health system, taking an inclusive governance approach, not just governing the public part, but also governing the private part. And here there are two reasons why we should be doing this. The first reason is that the private sector can actually play a huge part in the response because of their size and scope and scale and their activities. They can bring a lot of resources to bear to help us to deal with the response. And the second aspect, as I said in my introduction, there are private actors who haven't necessarily worked in accordance with the public health objectives of governments in the response. So governments do have a critical role to mitigate and address this situation, particularly in this phase of the response when we are very much focused on providing access to vaccines and other COVID commodities. And when those vaccines are scarce, we can't leave it to the market to decide how to distribute those products. So governments have a really important role here in relation to using legal tools and other tools in relation to the response. So I just wanted to make those very, very quick opening remarks. But now I'd like to pass over to the panel. And we're really lucky today to have such an excellent range of panelists from right across the region. So we have Associate Professor Bismarck from the Melbourne School of Population and Global Health. We have Dr. Nguyen from the Ministry of Health in Vietnam. We have Dr. Siom Kum, the Deputy Director of Legislation from the Ministry of Health. We have Margaret, I'm very sorry for any mispronunciations. We have Margaret Asumbu from the National Department of Health and PNG. And last but not least, we have Professor Wang from the Health Research Center in China. So colleagues, thank you very much for taking part in this session this morning. So I'll just pass over to Marie Bismarck to kick us off.
Thank you, David, and thank you to Jonathan and the rest of the team who've been organising this forum. I'm Professor Marie Bismarck from the University of Melbourne. Just a little bit about myself. So as you can see from my background, I'm a medical doctor. I'm working in psychiatry, and throughout the pandemic, I've been providing mental health care to patients in emergency departments, intensive care units, and COVID-19 wards. So what you'll hear from me today is very much a perspective informed by care at the bedside. I'm also a legal academic. I've recently written a book chapter on patient rights and practitioner responsibilities during the pandemic in a book edited by Ian Freckleton. And I'm a public health researcher involved with the Frontline Healthcare Workers Study, which is the world's largest national survey of healthcare workers from all parts of the healthcare sector, led by Natasha Smallwood and Karen Willis. Today, I'll be sharing some quotes from frontline healthcare workers from that study. So for me, in thinking about a whole of system response to the pandemic, the most important message that I would like to share with you is that many of the problems we've seen as frontline healthcare workers are not new, that they're an amplification of long-standing inequities, both in healthcare and within society. Yesterday, we heard a lot about legal mechanisms that are specifically designed to address infectious diseases and pandemics. And what I would like to suggest to you today is that there are a much wider range of legal tools that can be used to support the response to the pandemic. That what we've seen is that the pandemic has widened existing disparities within society and within the healthcare system, with profound consequences for patients and healthcare workers. Many of the challenges in responding to the pandemic, the ill distribution of resources, an overworked workforce, and worse health outcomes for marginalised communities, these problems were amplified, not created by the pandemic. So just a couple of quotes from doctors who responded to our survey. One senior doctor working in anaesthetics said, "The pandemic has shown up all the cracks in a chronically dysfunctional healthcare system." Another doctor working in an emergency department told us, "COVID hasn't caused any new problems. It has merely highlighted all of the existing inadequacies of the healthcare system." So thinking first about the way in which some of these pre-existing problems relate to health practitioners, I think that three major challenges we saw were insecure employment conditions, problems with workplace safety, and unsafe working hours. So here in Australia, a large problem in responding to the pandemic was the casualisation of the workforce, which meant that nurses and aged care workers were moving between sites and therefore able to take the COVID infection with them between different healthcare providers. I would argue with stronger and more secure employment contracts, we may have seen fewer healthcare workers required to move between sites for casual, insecure employment. A second problem was with inadequate enforcement of workplace health and safety laws in both public and private healthcare settings. Here in Melbourne, we saw delays in the provision of appropriate personal protective equipment to many doctors. So I was working on COVID wards and with COVID patients before we were provided with fit testing of masks, for example. Some of the people who responded to our survey said that if hospitals had been a mining site or another kind of private industry provider, health workers would never have been allowed to work with such inadequate PPE. The third challenge, and again, this was one that predated the pandemic, was unsafe working hours and an overworked workforce. I was really struck by some of the respondents to our survey. For example, one junior doctor said, even before the pandemic, on good days, we were already stretched. When something like a pandemic happens, we're expected to put in even more. There is no buffer. Another doctor working in palliative care said shortages of staff and resources worsened. The drain on junior staff worsened due to the increased clinical load. The only resource we had that we could increase was personal sacrifice of our own well-being. So I would argue that these problems with workplace health and safety, adequate resourcing, secure contracts for nurses and aged care workers were all problems that predated the pandemic, but were amplified during the pandemic. We also saw the importance of patient rights during the pandemic. And in our urgency to respond to the public health challenges, there was a real risk that the rights of patients and family members could be overlooked in public and private healthcare settings. For example, one really core patient right is the right to culturally appropriate healthcare. And yet we saw delays in the pandemic response reaching culturally and linguistically diverse communities. We see the disparities in immunisation rates between English-speaking and migrant communities. So there, I think greater attention to that patient right of culturally appropriate healthcare would have supported the pandemic response. Patients also have a right to appropriate support. This right was often overridden in the name of public health. I do wonder if one day we will look back and ask whether perhaps we went too far. I read many stories from nurses caring for patients who were suffering or dying alone during the most stringent visitor restrictions during the pandemic. One nurse working in palliative care said, "I am devastated our dying patients have been denied access from family and friends. It makes me sick to think these dear people feel alone and families feel so helpless." So again, I think that the right to have support from loved ones when you're unwell in hospital is a core patient right. And I think that as we continue to respond to the pandemic, we really need to ask whether all of the public health restrictions are proportionate and whether there is any way in which we can provide patients with greater family support while still protecting others from infection. The third area in which I think we saw amplification of pre-existing cracks in the healthcare system and in society is in the social determinants of health. Working on the COVID ward, I see the strong intersection between vulnerabilities. Many of our patients who are infected with COVID also have insecure housing, a lack of access to stable income. They may have drug and alcohol problems, disabilities, or not speak English as a first language. And I think that human rights law can play an incredibly important role during the pandemic, but also afterwards in addressing these intersectional vulnerabilities among patients. So, for example, one lesson that came out from the pandemic around the world is that in places where people are assured a secure basic income, it's much easier to enforce stay-at-home requirements. Whereas if people are fearful that they won't be able to put food on the table, they're much more likely to continue to work in violation of public health requirements. We also saw the importance of secure housing, that many of our patients who were infected with COVID did not have secure housing or were living in overcrowded homes. Again, that's a really basic human right and a problem that was amplified by the pandemic. And finally, I see the challenges of treating drug addiction as a criminal problem rather than a health problem. We've had real challenges in Melbourne with providing appropriate care to people who use substances who are infected with COVID. Without adequate trust in health authorities, it's difficult to achieve the kind of contact tracing and treatment that we need to provide to this group of people. And we really see the importance of a harm minimisation approach where addiction is treated as a health problem rather than as a justice problem, and providing appropriate health care to these vulnerable groups and community. One doctor who responded to our survey said the people who will do worst as the result of a pandemic are the people who would do worst anyway because of how society is structured. And I remember the writings of Lawrence Gostin, who says there are inextricable linkages between human rights and public health. Human rights require government action to protect individuals from harm and fulfill basic needs. So I think in thinking about a whole of system response to the pandemic, it's so important for us to keep in mind that many of the problems we've seen in responding to the pandemic were not created by COVID-19, but rather they were pre-existing problems that were amplified. And there's an incredibly important role for both public and private sector actors in enforcing and supporting those basic rights of health practitioners to a safe and secure work environment, the right of patients to timely access to culturally appropriate care, and the right of everyone living in society to a basic income, secure housing, and an environment in which their healthcare needs are met. Just a final quote from somebody who responded to our survey, who said there are many things we will need to reflect on from this pandemic once we get a chance to catch our breaths. I'm grateful for the opportunity that this forum is providing for us to all catch our breath and begin to reflect on what this pandemic means for our future. Thank you.
Thanks, Marie. That was a really thought-provoking presentation. I mean, I've been working a lot on the legal aspects of the pandemic here in Geneva, and you brought a series of issues that don't often get spoken about in relation to the pandemic, particularly from the point of view of the suffering of patients, the real suffering of patients and the experiences of health workers. So thank you very much for bringing that perspective to the panel today. So we have a slight change in order, I think, just because of the availability of some of the panelists. So the next person that we have to speak to us today, oops, sorry about this, just struggling a little bit with the technology. So the next person we have to speak to us today is Dr. Nguyen. Dr. Nguyen, over to you for your presentation.
Good morning. Good morning.
Good morning.
Ladies and gentlemen. Yeah, thank you for let me have an opportunity to here to join this panel and I have a chance to share some point of view from Vietnam concerning about the how the legal framework system engage the whole health system to be preparedness and respond to the pandemic, the COVID-19 pandemic. Vietnam, I'm from Vietnam, from the Health Strategy and Policy Institute under the Ministry of Health in Vietnam. Vietnam, we have experienced the 4 waves of the COVID-19 pandemic. The 4th wave is still the ongoing one, with also the most severe one has largely impacts on the whole the economic and health sector in the country. In Vietnam, the government has implemented the different strategy to respond to prevent COVID-19 at early stage of the outbreak with the very decisive action at the high level, both from the high level of leadership. A national steering committee has for COVID-19 has been established at early stage of the outbreak since January of 2020. This steering committee provides the leadership and stewardship leadership and the government at the highest level of the government. And this committee provides also the very strong mechanism to coordinate and govern leader of the intersectoral action to prevent and control the pandemic. Vietnam government made the decision to prioritize the health over the economic role. This is a very consistent directive from the highest level of the country leadership. The health sector is the center of the government effort to control the pandemic. Under leadership and government of leadership and the governance of the government, the whole health system has been engaged, has been mobilized, engaged in the health emergency preparedness and the response to this include health financing, health information system, health service delivery, human resources, and essential medicine and technology. It is observed that a huge amount of the legal document has been issued to legalize the government response to the pandemic. The Vietnamese policy system respond promptly, proactively, and effectively at the multiple level of the authority from the national to province level, and even province and district and commune level. This from study, it reported that during from the January start of the pandemic, January 2020 to the July of 2020, there was total of the almost 1,000 policy documents related to COVID-19 prevention and control has been issued, and which of that is 150 from the health sector, from Ministry of Health. Different types of legal document has been issued to meet the surging demand for policy response, such as the resolution from the highest level, including the National Assembly and the government, the telegram to address the matter, raising inspection, citizenship, circular to provide guidance to implement the document issued by the government, decision to solve daily tasks of the health authority, guideline, etc. To implement the legal document has been the issue, and also the good communication strategy is very important to in order to reinforce the implementation of on the legal document. The public is well informed about the legal the rule and regulation issued by the government and the Ministry of Health. The Ministry of Health informed the public of positive cases and potential exposure and provide guidelines for this disease prevention. The government also provides timely, clear, transparent, and tailored information to community to improve people awareness and understanding on the importance of their responsibility to implement on the rule and regulation issued by the government to prevent the COVID-19. This in the community, this improves the trust of population on the government. During the pandemic, the response not only from the public sector but also the private sector has been mobilized and engaged into the joint effort to control the pandemic. The private sector has provide the resources, including the human resources and also the financial and the medicine, medical supply and the vaccine for control the pandemic. So There also that the legal system had been also accommodated with the strong engagement of private sector in the pandemic control. The concerning one of the very critical issue during the pandemic control is about the how to protect the health worker who especially who are at the front line to prevent, control and the treatment of the COVID-19 patient. The government resolution issued by the government has to provide that all health staff who engage in the pandemic prevention and response are eligible to have allowance to provide the financial incentive for their effort to prevent and control the pandemic. On the other side, there's also regulation on to provide the reward to the health staff with the great achievement in pandemic control. So from the what we have from the what we have experience in Vietnam in general and on concerning with the legal framework development during the pandemic response. There's some we think that there's some key the lesson we think that one for responding to COVID-19 we would like to highlight here. The first thing is the commitment and the determination of the country leader is the requisite for the successful of epidemic prevention. And this strong commitment should be need to be the legalized into the legal document, legal system, and the document, legal policy document to provide the leadership and guidance to the whole the society to together to control the pandemic. The second point is the engagement of the entire political system and multi-stakeholder are very critical and in preventing epidemic. And the last but not the least is a strong legal capacity and the legal system is essential to support effective national response to the health emergencies for building a stronger and resilient health system to effectively respond and control any the health emergency or the crisis. So that's all for things I would like to share with you in this panel. Thank you.
Thank you, Dr. Non. That was a really great presentation. Thanks for highlighting the incredible importance of the whole of society response to COVID-19. And also thanks in particular for highlighting the important role of the political dimension and the importance of giving effect to political leadership through strong laws.
Yeah.
That was a very engaging presentation. Thank you so much. Now, can I invite Dr. Kwam from Cambodia to please give his presentation? Thank you so much.
Yeah, yes, I will let my sorry, I will share your screen.
No problem.
Okay. Anda sebelah mana? No. Yeah. That's screen itu. Desktop. Desktop. Sorry.
Dr. Khan, would you prefer if we share your slides for you?
Okay, I already see.
Okay, we'll share your slides. Thanks very much.
Yeah. Because it is I'll update a little bit about my slide. Okay, before we start my slide, I would like to say good morning, good afternoon, and good evening, ladies and gentlemen. My name is Konsinun, Deputy Director of Legislation Department, Ministry of Health. I would like to share my personal reflection regarding to session for engagement the full of the health system in the COVID-19 response to meet surging demand. Cambodia was one of the first countries to report the COVID-19 when the WHO declared COVID-19 pandemic on March 11. Cambodia had confirmed 5 cases. During the community outbreak event on February 20, 2020, a number of joint commission and legal documents were prepared and approved. The strength in the response of Cambodia to the COVID-19 pandemic was in part due to coordination between government agencies. However, we identify a few areas of improvement that may provide important learning points. While the COVID-19 pandemic is new issue or new problem for preparing health system response for Cambodia. So Cambodia have activated multi-sectoral, multidisciplinary committee to respond to COVID-19 at national and sub-national level to manage public health emergency mechanism and coordination. This includes the formation of the National Committee for COVID-19 led directly by the Senate Prime Minister. The committee is responsible for setting national policy strategy for the COVID-19 response, leading the implementation of the strategic plan for the prevention, control, and management of COVID-19, and responding the associated political, economic, and social impact at all levels. Sorry, it's not go through to my slide. Yes, okay. All hands on deck for the task force at the national level, sub-national level, and engagement of private service sector through the implementation along with health management. And the last point, you will see the lesson learned. Yes, this is a national level. In early April 2020, the royal government of Cambodia announced the creation of the Inter-Ministerial Committee to combat COVID-19, led by the Minister of Health. CDC, Minister of Health created an emergency operation center coordinated by Department of Communicable Disease and Control. And after we call NIPA, Pasteur Institute, and the Pasteur Institute, and include also the military hospital, will play an important role to serve lab service and including certified health certificate. During that time, 4 national hospitals were set up to treat critical COVID-19 patients. And also, 1 new hospital was established for COVID-19 management facility. Referral hospital and health center was transferred and supervising by the capital administration was also prepared in response to COVID-19. In addition, the Ministry of Health has signed MOU with the number of major hotel, restaurant, and school, as well as location for treatment of minor COVID-19 patients, and also as a place for quarantine, including national stadium as well. Other institution in Ministry of Defense. Ministry of Defense has also military, we call a military hospital. The military hospital serve a treatment of COVID-19 and a place for vaccination in providing both civilian and military vaccinated. Other body is a medical volunteer. We call a TIDA, was set up by Prime Minister, have been involving in set up a new location for treatment and sampling of COVID-19, such as the location at the Gulf Beach and in the Iceland Diamond. This volunteer include more than 3,000 health worker volunteers. So until now, all these 3,000, they became a health official directly. Other body we call a National Police Commission. The National Police Commission was a subcommittee on research and surveillance of suspect COVID-19 virus. It also been active in enforcing the law on the individual who violate health and administrative measure. The next committee we call the Sub-National Committee that joined the COVID-19 also with the same approach with the national level subcommittee, a sub-national committee level to engage the pool of principals in the fighting against COVID-19. It was also being replicated at the provincial level led by each provincial governor. The committee is responsible for setting provincial strategy for the COVID-19 response, leading the implementation of strategic plan for the prevention, control, and management of COVID-19, and leading and managing the provincial health system or health department at the province. Yeah, the next is the private sector or private health service. During the increasing of positive COVID-19 patients, the royal government had flexible decided the engagement of the private health services to examine and treat the COVID-19 patient. So during this, so I would like to share some idea also regarding to working process relating to the system management. Before I said about the lesson learned. So at first we call multi-sectoral and multidisciplinary committee was responsible with COVID-19 at national and subnational level that I mentioned about, and after the CDC responsible. And another flow of the implementation of the health system is surveillance and contact tracing and respond to COVID-19. Contact tracing operation led by Ministry of Health were added by dedicated contact tracing team at the hospital and army hospital, and also volunteer medical team. Laboratory service, it is that I said is responsible by NIPH, Pasteur, and military hospital. Quarantine measure at the point of trial. It depend on the reflection, the duration of the quarantine. At first, we spent 14 days, but now the Cambodian is flexible and cut down the day of the quarantine until 3 days, 7 days, and 14 days. 3 days for Khmer and foreign citizens that and investment people. 17 days and 14 days for unvaccinated and insufficient vaccinated though people. Yeah. Related to case management, since identification are the first important various phases of travel restriction were implemented. Individual who tested positive was immediately isolated and interviewed for the contact tracing. Infection prevention and control, we also provide the implementation of broadcast by the TV to introduce or to practice a good hand hygiene, avoid touching face unnecessary, must appropriate and minimize contact with other when unwell. Seek medical aid at the earliest onset and any respiratory symptom. Especially advised to practice 3-DON and 3-DAS as the government of Cambodia always fit with the all cell phone. 3-DON, 3-DAS, and mean don't go with the crowded people, don't join a close place or touch each other or shake hand. And 3-DAS, it means wash hand regularly, wear mask when go outside, keep social distance. It is the government practice, broadcast to the people of Cambodia. And after for risk communication management, the task force was transparent and frequent in providing situation update through social media channel and regular press conference. This nationwide communication channel was vulnerable and misinformation. Ministry of Health regularly clarified misinformation and encouraging the public to follow accurate and reliable information on official channel by Secretary of State. Vaccination is provide a free of charge defined by subsidy. It is a mandatory for the frontline worker such as health worker, civil servant, armed forces, judge, prosecutor, etc. And prioritize also for the vulnerable and disabled people. Logistics and supply. When the outbreak started, the government declared that it would finance treatment costs incurred by COVID-19 patients in public hospital. Royal Women of Cambodia received financial and material support from rich people and companies when the COVID-19 first started. Legal foundation. Two, law and for supplementary and other related legislation were enforced to complement policy measure in managing the outbreak. It declared a national emergency to maintain national security and public order to protect the life and health of the people. It also provided legal basis to enforce social distancing measures such as limitation of mass gathering and holding individuals, as well as business owner accountable for violation. mobilizing another, the last point is mobilizing resource, human, budget, and logistic quarantine place, such as he has allocated to the subnational level and collect and supported by rich people and other companies also. And all the health workers have to train to wear a PPE properly. Lesson learned. I'm sorry also on this slide that I sent to you. Yeah, it's not reply to the lesson learned from Cambodia. Yeah, so I would like to tell about that directly. Yeah, it's not this slide. Okay. Some lesson learned that the government provided fast and effective response to control the spread of the virus is 4 options, 4 categories. At first, by the implementation with a good cooperation and good coordination according to multi-sectoral and multidisciplinary committee. Second, receive more financial and material support from rich people and companies. Third, strictly adopted and approved COVID-19 regulation, including guidance on diagnosis and management of COVID-19 and on infection prevention and control guidelines. Fourth, established the clear legal framework reduces the possibility of misinformation during crisis and enhance clarity in risk communication. Thank you for your attention, and I'm waiting to learn from all of you. Thank you.
Thank you so much for that excellent presentation on the wide variety of areas in which law has become incredibly relevant to the operation of public health system when it comes to COVID-19. It's fascinating in that last presentation to hear about all the different aspects where law has played such an important role in the response. And also thank you so much for highlighting the challenges of addressing these matters when you're dealing with a health system which has more than one level, where you have a very complicated health system in Vietnam, where you have the subnational level, which is also very important. So thank you very much for that great presentation. So now I'd like to pass over to Margaret from PNG. Over to you, Margaret.
Okay. Hello, everyone. Thank you, University of Melbourne, Jonathan Lieberman and the team. Thank you, WHO, Genevieve and the team. Thank you, everyone, for sharing, because we have learned a lot from every personal experiences in their respective countries. I'm Margaret. I'm the legal officer for the National Health Department, Papua New Guinea. What I'll be sharing is I'll be answering the 5 questions, and it will be really based on the experiences that Papua New Guinea have experienced during the global pandemic that has affected the country and the global as a whole. Okay. From experiences, we have realized that to attend to COVID-19 public health emergency, it is very important to have a national law that is actually setting a benchmark where it actually allows the whole sector approach to public health emergency. And we have seen that having public health emergency declaration at the national level under the Constitution was very helpful, because it actually brought every private sectors, public sectors, industries together to manage addressing the public health issue relating to COVID-19. We also realized that we have to modify the public health laws that we have in the country, because the public health laws did not really adequately address the international global pandemic. So we realized that although we had these laws in place, we saw that they had to be modified. We also see that the other laws can also help to support approaches of public health emergencies, and that includes other laws that are regulated by other departments and sectors. And one of them was the Public Finance Management Act, and that was very important to regulate the finances that were coming to support COVID-19 in Papua New Guinea. We also realized that we also need to modify the Public Service Management Act, because at that time we had capacity issues, because we had to manage the public health issue very effectively, and there were laws that actually gave limitations to that. And Public Health Management Act need to be modified to address public health issues. So we attend to public health matters collaboratively. We also realized that the Procurement Commission Act, which is responsible for procurement of medicines, was a very important act that also came in to support the public health emergency when we were faced with it. And so as the Medical Registration Act, we had supports coming from other countries, and those countries' professionals were required to be registered under the Medical Professional Registration Act. And those were some framework in place that actually supported the whole approach to health sector attending to public health issues. This legislation really needed to have clear roles and responsibilities of each level of health system, reporting, accountability, and there was a really requirement for partnership support in the legislations. We also realized that they should be, in the other laws, they should at least provide for public health emergency provisions, which should be also captured under different laws. So then they will also, it would also specify their roles and responsibilities to support public health emergency preparedness. The legal framework support and hindrance to emergency preparedness. Although we had laws that were a bit outdated, and but their laws still provided for some control measures, quarantine measures, and public health measures. But we were fortunate that we had a constitution that actually supported the public health emergency through the declaration or state of emergency, and that compel all sectors to address public health, and private sectors, churches and non-government organizations. We also had the Pandemic Act that was developed in 2020, and that also improved the reporting and accountability and control measures applied to the public health emergency matters. We also had some issues with the hindrance that were faced during that time, where there was, because of it was a sudden surprise for the global public health pandemic. There was a bit of confusions of roles, and there was duplications of roles. There was no clear demarcations of the roles and responsibilities of each sector. There was no clear path of reporting, and there was lack of accountability. There was inconsistency in reporting between relevant authorities, and there was lack of staff to actually effectively manage the public health issues that we were faced in the country. Our laws did not adequately address emergency preparedness of a global public health threat. But like I said, although we had all these issues, it really got the team together with the support of the constitutions, with the support of every other health, private sectors, other government sectors, under their own law. They came in and they provided assistance to all the country in terms of trying to provide an effective measurement to public health issue that was faced in the country. Involvement of private sector. It was very relevant for the involvement of private sector. The private sector actually assisted in a lot of ways. They came in big time in actually providing support to assisting the public sectors, and that was through management of public health issues. They provided treatment, transportations. They also provided use of facilities to manage the public health issues. They provided role of vaccinations, sharing of workforce and facilities, coordination, reporting, and accountabilities. So there was, we saw that they came in those matters, but they really need to be in this current lessons learned from the current approach is that they came in a big way, but we need to really strengthen the strategies involving coordination, reporting, and accountabilities. Because the challenges that we faced was that there were policies that were also set by private companies and industries were a bit stringent to public. And we thought those were some challenges that we really need to address adequately through some form of arrangements, agreement, and working closely with different sectors and coming up with the best policies and regulations that will really allow the private sectors and the public sectors to work collaboratively and harmonize service provision. For mental health legal framework, yes, we do have a mental health act. It does provide the directorate, which was very supportive to provide mental health counseling, training to health workers. Although the act did not really specify public health training and counseling to health workers, thank the World Health Organization, it provided guidelines to set up national plan for training and counseling for health workers. So in the country, we have the psychiatrists who are actually running this counseling and training for our health workers, and even providing counseling to patients. And they're actually going out through media and phone calls, and there were times that they have to come face to face to provide these counseling services. So, but we will still, through these challenges that we have faced, the mental health act need to be really amended, modified to really suit current issues that are faced. There's so many mental problems, issues, stress. People are overstressed, staffs are overstressed because there's not enough staff. The new people who are coming out of colleges who've just trained and registered are coming into support. They're coming into support, but they also need to be properly trained and prepared mentally to go in and approach. Yes, we are actually approaching the mental health issues through our mental health act. So we are working closely with WHO to provide that support for our staffs and even patients. Lastly, the lessons that we have learned through this is that it is important to have a whole government approach because it's a public health issue that is affecting the whole country, and different governments have their own responsibility to do that. You know, sometimes we need to really have these directions coming from the government. So we realize that the whole government approach is very good for an effective partnership agreement specifying roles and responsibilities of both public and private system. We also realize that the international health regulation is to be domesticated into the national public health law. Yes, during the COVID-19 breakout, we realized that the international health regulation was one of our strengths that guided us into how we could manage an international pandemic. And we also realize that international health regulation under our constitution should be domesticated into the law, so it becomes something that's mandatory for everyone in the country to comply with. And it is actually recognized under the national law. We also realize that all other supporting laws, the other laws which not health is regulating, but the other departments are regulating those other laws, they really need to incorporate management of public health emergency provisions. And then it really needs to outline what is expected of them when there's an emergency as such happens. So we can all know exactly how each and every one can cooperate together to manage effectively public health issues now and any other that arises in the future. We also see that we need to have very effective partnership agreement, specifying roles and responsibilities of both public and private health systems. Private health sector to work closely with health department to avoid breach of public health requirements. It is very important that because health department is the health agency that's responsible for delivering of health services, public health, private sectors need to work very closely so we can work together, so we are all on the same page and we are all working together as a team and providing the country the relevant services to people who need the services. Legislations to also consider human rights requirement under the public health during public health emergencies. Right now, we have a lot of issues concerning public health issues versus the private rights. And we have realized that because it's a public health concern, it has tried to impinge on individual human rights by stopping them certain rights, that they have rights to go to work, right to pay, right to doing things that it has been regulated. And now we have court cases that have been brought forward, and they have actually tried to, the lawyers that are taking it on now at the moment, and now it's before the judge with the National Court, and the National Court has actually directed our controller under the Pandemic Act, the health minister, and the National Executive Council to present before the court on the 16th of November to address this issue. So human rights is becoming an important consideration under such emergencies, and there needs to be clear guidelines as to how we consider public health versus individual human rights, individual human rights, yes. And we need to continue providing training and counseling in the management of health emergency. And this kind of training model should not be only applied to health department, but it has to be also applied to other departments and private sectors, public sectors, and each and every one should be aware of the training that's required for attending to public health emergencies like we have the COVID-19 right now. And there should be counseling, not only for health workers, but they should be also counseling for our patients as well, because there was no counseling from the start. You know, people were a bit distancing themselves away from even COVID patients. But I think COVID needs to be seen as just another disease, and as a responsibility for health workers, we need to be counseled to counsel our patients who are actually there to receive that expert care from us. So we see that those are some lessons that learned, and we need to work closely. Every sectors need to work closely together. Roles and responsibilities need to be clearly demarcated, and we know what to do, so we do not step into each other's toes. We do not duplicate roles and responsibilities, but we all are working together, and we all are working towards a common goal, and that is to make sure that we control public health issues and we effectively manage public health issue, and even in the future, whatever that may happen. From this, we have learned that we need not to just sit back and be complacent, but we need to be very proactive in managing public health emergencies in the country. And a strong legislative framework is something that will contribute to effectively managing public health issues arising in the country. Thank you very much.
Thanks, Margaret. Thanks for that very careful and thoughtful analysis of how law has both helped with the response in PNG, but also for the analysis of where you've had some problems. Also, thanks very much for highlighting the importance of a whole of government approach to this pandemic and making sure that the Ministry of Health works carefully with other ministries who have an important role here. It's great that you also brought in the human rights dimension, as other speakers have as well, and also the importance of mental health. So thank you. Thanks very much for a really thought-provoking presentation. Dr. Wang, would you like to take the floor, please?
Thank you, David. And well, thank you for the organizers to invite me to participate in this very important meeting. And I really learned a great deal from the previous speakers and the experience from different countries. I benefit a great deal. Now let me share my presentation from the Chinese perspective. Just wait a minute, I would like to turn on my slides. Okay, is that all right?
Yes, we can see your slides. Thank you. Could you put them into presentation mode? Thank you.
Okay, sure. Well, thank you very much. So I will talk from the Chinese perspective. And because of the limit of time, I will not repeat what the other speakers already eloquently emphasized on. And for example, we need to pull all the efforts, not from the only epidemiologists or the public health organs, but the entire health system. I completely agree with that. The previous speaker, Mary, already mentioned the vulnerable group of people who have greatly affected by the pandemic, and also other persons and with chronic disease, with non-infectious diseases, and other kinds of diseases who are actually affected by the pandemic. Therefore, we should pool all the efforts, not from only the public health agencies, but from the entire health system. And in China, the health system, particularly the healthcare service provided by the hospitals and the clinics, the major part of the hospitals are state-owned. Therefore, the government have a great leverage in mobilize the enough efforts from the other hospitals and clinics in order to effectively contain the COVID-19. And I think everyone remembers that at the beginning of the outbreak of the pandemic in China, there was shortage of the manpower, of the physicians, nurses, and also there was not sufficient space for hosting all the patients. So therefore, they were quickly encouraged and mobilized by the government to set up the so-called mobile cabin hospitals to create enough space to take whoever need the healthcare service into these additional clinics and hospitals. So we could say that these efforts need to be gathered not only from the public sector, but also from the private sectors as well. And physicians, nurses who are in the private sectors also participated in the containment of the COVID-19 in China. So what I would like to say is that not only the efforts from the health system, health sectors, we also need to consider the efforts from the entire society. In China, we have an expression, which is that the fighting against coronavirus is a war by the whole people, not only by the doctors, physicians, or health sectors, but by the entire society. And is also called multi-dimensional war against the COVID-19, namely all the sectors, all professionals, or other organizations need to participate in these great efforts to contain the COVID-19. And besides the health sector, we could say there are pharmaceutical industry in which mobilized and expected by the whole society to produce very efficient vaccines and drugs, etc. And also market supply, not only the health equipment, but also daily necessities and for their food and for their drinks, etc. And also transportation, because it's a vast country, people are moving all the time, and how to really contain the COVID-19 depends on transportation and many other sectors as well. All the social organizations need to participate in this war, and the entire government organs. And for example, at the beginning, we made a suggestion to the Ministry of Transportation and informing them that they should really use their efforts to cut the transmission of the virus through public transportation. So these kinds of participation by all the government organs are really necessary and indispensable. And most importantly, in China, the organ which is interim organ in the period of pandemic was established, which is the Joint Prevention and Control Mechanism, which is the leading and coordinating organ at the central level, and also the similar organs are established at the local level to make the effective mechanics and coordinating organs to really pull all the sectors of the society, all the organs of the government together in order to make effective fight against the COVID-19. And of course, in China, there is a particular political system, which is the leading party, which is the Communist Party of China, which has great significance in guiding the government and also mobilizing people to engage in the fight of the COVID-19. So I would like to say, probably we could enlarge a little bit, not only engaging the entire health sector, but the entire society, which is really needed. And why law is crucial in response to COVID-19. I will not repeat what the other speakers already eloquently spoken. I just want to point it out, the unique feature of the current pandemic. Their unforeseeable eruption of the new disease. And in China, in Wuhan, in the early stage, and there are no sufficient time for testing, or even to separating the virus. And there was no knowledge of this new virus. So people at the beginning were panicked and didn't know how to deal with that. The health authority quickly mobilized the physicians and the scientists to find out what are the new variants, how to cope with these new variants. But regrettably, still to the present stage, there is no effective medicine, no effective therapy. The vaccine at the beginning, for a long time, more than 1 year, there was no effective vaccine as well. But now we do have vaccine available, but they still cannot provide indue effect against the virus. So we are limited by the technology. We are limited by our knowledge. So what are the effective tools or measures for containing the pandemic? And then we recall the historical experience. We find the traditional ways are very much effective vis-a-vis the new virus, which we have no effective drugs and therapies to cope with. So this effective traditional way is actually quarantine. So this is the most effective way to cut off the transmission, channels of the virus, and the most reliable way of keeping people safe. So these include blocking the channels of the virus transmission, the quarantine, or keeping social distances, etc. We wearing the masks in the public. We know all these ways and adoptions, measures, which are not really some high tech and depending on the traditional way. So here, from the legal perspective, we understand that the functions of law include so many, and to delegate authority to the government, to protect the human rights, to, provide punishment and the legal ground, etc. We could name all the functions. But considering fighting against the current COVID-19, the law's important function is to regulate people's behavior, to advise people what are the healthy way of participating in your social work, in your professional work, etc. So the function of law is to regulate people's behavior. And then we think that, the way currently we are applying are actually changing people's behavior in the public places or in their private homes. So they are hand in hand. They have the internal logics, similar logics of providing norms which will change or regulating people's behavior. So this is why in this current pandemic, law is indispensable from the very beginning, from the privacy, from the other freedoms, from their property rights, etc. We can see that law is very much indispensable. So this is my view, and we need to engage the whole society, not only the health sector, and also law is indispensable. And from particularly the perspective of the current pandemic. And in China, I will not dwell on these parts. And there are different, fields of law. Every lawyer knows about it. And Chinese legal system is a whole category. Within it, there are different compartments, different fields of separate laws. Health law is one part of it. But health law contains many subfields as well. And here's the chart from the Chinese perspective. We illustrated that public health law is only one part. It's not the entire of the health law. Health law contains public health law, health care law for individual patients. Public health law concerns the public health. From the legal perspective, there are different fields. And also finance and insurance for health and health products law, including the drug law, vaccine law, etc. So I will not deal with these details, just to give you a general picture of what is the legal structure, what is the importance of health law, and also particularly the public health law in China. In coping with the current pandemic, and China never declared emergency stage, but China declared contingency state. The contingency state is provided by the emergency response law and also constitutional law. In China, there are two kinds of concept: emergency state, contingency state. For coping or fighting against COVID-19, China entered into contingency state. Even though this is the minute legal jargons, legal distinctions, I will not deal with that. We may use emergency, contingency interchangeably. Anyway, not from the strict legal perspective. But what are the characteristics of contingency stage? And is a particular abnormal stage declared and terminated by the proper authority, namely by the administrative organs. The highest one is the state council, and then the local provincial governments. So they are the authorities who can make decision for declaration of contingency stage. So what are the particular characteristics of this stage? It's abnormal stage. In this stage, many people's rights, citizens' rights, and the rights of social organizations such as enterprises, substantially restricted. So namely, in order to contain the virus, in order to keep people safe, and there are certain limitations has been imposed on citizens, on other organizations. So here comes the difficult part of public health law, which has been eloquently advocated already by the famous legal law professor, Larry Gostin in the US. In his famous book, Public Health Law, he mentions that public health law organs and authorities and decision makers face an inevitable dilemma, which is you have to make a choice, to make a decision, which have to be based on trade-off. You have to select which are the rights you want to protect the most. What are the rights or interests at the moment need to be suffered a little bit. And the trade-off, I think the speaker yesterday from Singapore already mentioned this term, trade-offs. While making trade-offs, the government is gathering more power in its own hands, and the individuals need to be limited in their rights. You have to make this trade-off. What are the general principles you need to have? So it's not a kind of trade-off decision at random. There should be some legal guidance, legal procedures. I would say principle of legality, which contains the principle of legitimacy, whether these measures, authorities are legitimate, and also principle of proportionality, whether the trade-off decision, the kind of quarantine measures actually proportionate in order to protect more benefits and then create less harm.
Yes.
So is time up?
Yeah, sorry, Dr. Wang, I'm sorry to interrupt you. This is a great presentation, but we only have a little bit of time left, and we do want to keep some time aside for discussion.
I understand. I understand.
Thank you so much.
Completely. Can I just finish with another more couple of minutes? And in China, and through the process of containing of the pandemic, and we are actually in the whole process adopting very flexible policies. Namely, we're changing, even this is at a normal stage, but there are different flexible policies has been imposed and adopted. Now, I just want to share the lovely photo in the Disneyland in Shanghai. Just a couple of days ago, there was an eruption of confirmed cases in the neighboring province, and one confirmed patient went to this Disneyland. They landed the news in the evening at 6 o'clock. Within 1 hour, they gave a public announcement. All the people need to have the nucleic acid test immediately. So by the 9 o'clock in the evening, and more than 10,000 people has been tested. And all the close contactors has been traced off. And then there was some immediate measures has been imposed. So this is a kind of more accurate, swift, effective, and scientific controlling measures. And particularly the so-called fall earliness mechanisms. I will not repeat what are the earliest: early detection, reporting, control, and treatment, etc. So China is going to systematically review the current health system, legal system, and give already a decision by the National People's Congress to revise or to enact to the new laws in the future. And just one more minute, sorry for that, David, sorry for that. And after the pandemic, and we should learn from the historical experience, we may consider further in the bundle of human rights, any kind of ranks or orders of different kinds of rights during the pandemic, which is an enormous danger for the entire mankind, whether the right to health, right of life should be put into the upfront. And also we need to make the government and political leaders legally committed. Not only change the law, but they must make the commitment in various ways I will not repeat. And also adopt the adequate and proportionate quarantine measures together with the provision of additional service, assistance, protection by the government, and emphasize equally the mechanisms of both preparedness and response. And I say in terms of response, there are a lot of, well, kind of incidents in which the lack of the legal commitment by the leaders, political leaders. So I think this is very much important. And also embrace and implement the idea of one species and one planet and one fair shared future, which is provided by Tedros, the current Director General of WHO, and also which echoes President Xi Jinping's statement, a community of common health for mankind, and in the framework of the community with a shared future. I think this should be firmly adopted. And thank you for your attention. Sorry, I spoke too much. I stop here.
Thank you, Dr. Wang. Thank you for highlighting the importance of making sure that we keep laws up to date. That isn't the laws are just a fixed point in time, that we really do need to learn from this pandemic and make sure that we do keep them up to date for future challenges. I'm sorry, we're going to have to close the session. We've had some excellent presentations today. So thanks to the speakers. So if anybody who'd like to make some comments or pose any questions to the speakers, could you please put them in the chat or in the Padlet? That would be great. So thanks everybody for your attention to the session, and back to Jonathan.
Thank you very much, David. And thanks to all panelists for a fantastic session. I see there are some interesting comments already on Padlet, so I'd also like to encourage people to add to those. We're going to take a 10-minute break, and we'll be back for the session on building and mobilising legal capacity at 10:50 Manila time. So thanks very much, everyone. Welcome back, everybody, for session 5, Building and Mobilising Legal Capacity for the COVID-19 Response and for Legal Preparedness Beyond COVID-19. A reminder again for those who are joining us by Zoom, the forum is being live streamed on the Melbourne Law School's YouTube page, and we're recording, and we'll post the forum not long after the event concludes. So in this final session, we've been discussing over the last couple of days the critical role of legal frameworks across a number of different priority areas and how important it is that we get our frameworks right, which is partly about law on the books, but it's about much more than that. It's also about how we're able to implement frameworks effectively in practice, how we can monitor their impacts, how we can monitor these impacts on different groups and individuals, and particularly on vulnerable, disadvantaged and marginalised communities, and that we're able to review and improve our frameworks as circumstances change and as our knowledge and experience evolve. So this includes understanding and harnessing interactions across different legal frameworks within the same jurisdiction, across overlapping jurisdictions, for example, national and subnational, as well as international legal frameworks, working effectively across government agencies and across sectors beyond what we might sometimes think of as health law and the health sector, working in partnership and collaboration with the community and with the private sector while regulating it. So in this session, we're going to discuss how we can build and mobilise the legal capacity that we need to be able to mobilise to do all of this effectively for the ongoing COVID-19 response, for health emergencies beyond COVID-19, and more broadly for health system strengthening and to achieve universal health coverage. So we've got a fantastic panel for this session. So I will, I think there's a slide, there might be a slide coming up with you all on it, maybe not. Okay, so the panel, I'll mention them all now and then I'll come to them individually. So we have Professor So-Yun Kim from the Asian Institute for Bioethics and Health Law at Yonsei University College of Medicine. We have Hayley Jones, who's the Director of the McCabe Centre for Law and Cancer, Miles Young, Director of Human Rights and Social Development at the Pacific Community, Dr. Rahani Jahis, Head of Zoonoses Control Sector, Ministry of Health, Malaysia, Delphina Kerslake, Assistant Chief Executive Officer, Legal Office of the Director General Health in Samoa, and Melee Tangivakatini, Government Lawyer, Department of Justice, Nauru. Now, before we get to the panel, Alyssa will show us the Padlet for this session.
Thank you, Jonathan. And just a quick reminder to all the speakers for the session to please turn your cameras on so that we can spotlight you. Thank you. Great. So for this session, we're going to do things a little bit differently. We only have one final Padlet left, and I'm about to just share that with you on the Zoom chat right now. So if everyone can go into this link and type in the password, the same as before, health law in small letters, you will be led to this page where you will find 4 different questions. So as we approach the end of the forum, we really like to hear your thoughts on these. So the first one is, what were some of the important points that came out of this forum for you? Second, is there anything that you think that you might apply within your own country? Third, what kind of actions would you like to see in the future from your country, from WHO, or from others? And then finally, any other comments or feedback on the forum? Please feel free to share your thoughts with us here as we go along with the session and also during the closing, and we'll keep this Padlet open for the next 24 hours as well, just in case you want to reflect on these questions a little bit after the forum. Thank you very much. And as always, I'm here to support if you need any help with accessing Padlet. Back to you, Jonathan. Thanks.
Thanks very much, Alyssa. So we do want to have time for discussion at the end and also some time for the Padlet. We've got 6 presenters, so I'm going to ask you all to try to keep to time. And if you do get to 10 minutes, I'll let you know. So first over to Professor So-Yoon Kim from Yonsei University College.
Thank you, Chair, and thank you for the WHO and Wipro team. Yeah. I'm very glad to participate this forum. In 2010, the former Director General of Wipro, Young-Soo Shin, requested to the Myung-Se Son, my senior professor, to send the legal expert to the Wipro office for supporting the each country's legislation. So I was sent, and then I worked as a legal officer at Wipro Manila for 9 months. And in 2011 May, we host the legal expert meeting for supporting the each country's legislative capacity building system setup. Genevieve was one of the coordinator, and David Clark was one of the expert consultant at the time. And from the time, myself and Yonsei University continuously involved with the legal activities of Wipro and became the WHO Collaborating Center for Health Law and Bioethics from 2014 until now. And from the 2011 May meeting, we continuously want to build up the domestic researchers and capacity building of each country. We provide self-analysis tool for analyze their own laws and set up the websites. And we also support to set up the Korean Parliamentarian Forum on Global Health and also Asian Pacific Parliamentarian Forum on Global Health. The reason why I present this history, it is very closely linked to discuss point of today. So I want to question and answer for this sections and part. So the first question was, how can you better demonstrate the role that the law plays in supporting effective public health emergency preparedness and response? I think that it would be great to examine a policy compliance and compare result with and without the presence of legislative measure. For example, about the self-isolation. In some countries, they have law for supporting the self-isolation, and in some countries do not have. And we can compare very closely. And how can you check the isolation, self-isolation is performed thoroughly? Someone should be able to monitor the person, whether the individual are self-isolated or if they are not, they should be penalty. Yeah. So, and in addition, someone should help the self-isolated person to live their daily life. So if we have only the legislation and do not have the infrastructure system for supporting or monitoring, the law cannot be implemented. But if we do not have the law itself, that infrastructure system cannot be set up by the social fund. So legislation is the first step for setting that kind of infrastructure and monitoring and doing the penalty for the violating the laws. So this kind of legislation and observation, the with and without the legislation, how the system can work is observation. That kind of things is very important. And that kind of things can be done by the government itself, but also can be done by the researchers. So research about these kind of observations is very important. And the second question was, how can harness the lesson and attention on the roles of law to both supporting the ongoing COVID-19 response and strengthening legal preparedness for future health emergencies. I think it should be better to collect legal responses and experience from each countries and establish the knowledge and information share system. The system can provide not only legal ground, but also the practical information on infrastructure building and experiences. And for the third question, how can we ensure our efforts to strengthen legal capacity and preparedness also contribute to broader health system strengthening and advanced UHC? I think the making of law means that the society as a whole realize its importance and feels necessities. This will be an opportunity to strengthen general health capacity by supporting the health response related infrastructure and manpower capacity building. So legislation itself is very important meaning for advancing the UHC, I think. And fourth, what action can WHO and development partners take to support those at a country level to strengthen legal capacity and implement needed law reform? I think the regular and continuous capacity building opportunity like this kind of forum, but it should be predictable and continuity should be done. Many participants may not be changed and added, just not be dropped. They can be the important rule in their countries. So this kind of activity is very important, and I already mentioned the setup, the knowledge and information sharing system, network system, is very efficient for each country to learn from that. And what are the priority action for building legal capacity for health emergency partners, particularly at country level? I think at the country level, they also need the manpower build up, capacity building. So select the legal experts at the government level, academic level, and parliamentary level to continuity and continuous activity for capacity building and research and implementation about the health law field is very needed. Thank you for your attention.
Thank you very much, Professor Kim, for those remarks. So I think just what I took from that, some of the main themes that there are roles for both government and for researchers outside of government, how important it is for us to be collecting and sharing information so we can learn from one another. And I think you made a really important point about continuity. We need to be doing this on an ongoing basis. So thank you very much. Now I'll turn to Hayley Jones, who's the director of the McCabe Centre for Law and Cancer. Thanks, Hayley.
Thank you so much, Jonathan, and it's a real honour to be part of the forum and to be alongside such distinguished speakers and participants. So thank you very much for the opportunity. I do have some slides which I think colleagues at WHO will kindly share for me. But to make a start, I would like to acknowledge the traditional owners and custodians of the lands that I'm speaking to you from today, the Boonwurrung people of the Kulin Nation, and pay my respects to their elders past, present and those emerging, and to all First Nations people who are joining us today. And next slide, thanks. As part of my presentation, I'd like to give some background on the McCabe Centre for Law and Cancer and make some reflections on our work building capacity on the effective use of law in the fight against non-communicable diseases, and particularly thinking about how to harness these lessons and how they may be transferable to support the ongoing COVID-19 response and to strengthen legal preparedness for public health generally and for future health emergencies. So the vision of the McCabe Centre is a world free from preventable cancers and in which all people affected by cancer have equitable access to safe, effective and affordable cancer treatment and care. And our mission is to promote the effective use of law for the prevention and control of cancer and other non-communicable diseases by building knowledge, expertise, capacity and networks at global, regional and domestic levels. And as my colleague Professor Kim was mentioning, we're also very proud to be a WHO collaborating centre. We're a collaborating centre on law and non-communicable disease, and we're proud to work with WHO colleagues and support member states in their efforts on using law for NCD prevention and control. And we're also proud to host the WHO Framework Convention on Tobacco Control Knowledge Hub on legal challenges to the convention's implementation. Our team is based across a number of places in Melbourne, also based in Fiji, the Philippines, Kenya and New Zealand. And I do have to pay tribute to the vision of Jonathan Lieberman in establishing our centre back in 2012. So well done, Jonathan, and we're proud to continue this work. Next slide, thank you. So cancer and other non-communicable diseases are still the world's leading causes of death and disability. And only now they're also making people more vulnerable to COVID-19. And the COVID-19 pandemic is hitting marginalised communities the hardest, just as NCDs do, underscoring the same inequities. And it was really interesting to hear Dr. Bismarck's reflections on that this morning. 8 million people died last year due to tobacco use, while the tobacco industry continues to encourage people to smoke despite a pandemic of respiratory illnesses. While there's been a high level of political commitment to take action on NCDs over the past decade in particular, including goals and targets set out in the UN political declarations and in the Sustainable Development Goals, significant effort has always been needed to make progress, and this is even more challenging in the context of the pandemic. In our work, we aim to promote empowerment and building the capability of individuals, organisations and governments to use law as an effective tool to prevent and control cancer and NCDs. And we use deep technical research to produce world-class thinking, spurring practical action to face cancer and NCDs head-on. We have a real emphasis on fostering collaboration to bring together the brightest and most passionate minds from all over the world to impact the prevention and control of cancer and NCDs. Next slide, thanks. So a key aspect of our work is a range of training and capacity building programs which we've run since 2014. And we've trained over 270 people, mostly government lawyers and policymakers from around 77 predominantly low and middle income countries to build capacity in law and non-communicable disease prevention. These were previously primarily in-person training courses, but we've now adapted to running online training and networking opportunities over the past 18 months. And I'd like to draw out some important elements of these trainings and workshops which are relevant to consider for other kinds of legal capacity building, such as for capacity building on law and COVID-19. We situate our training within broader frameworks and showing the connections between them, such as the Sustainable Development Goals, human rights, gender, trade and investment, and we don't just look at NCDs in isolation. Underlining this, we emphasise the importance of multi-sectoral coordination to achieve these goals. And as with the forum today, the two-way sharing of experiences is a really crucial part of our trainings and workshops. Participants are asked to present on their work as part of their training and often make connections and exchange information with peers, and we always learn such an enormous amount. For our intensive course, participants are asked to scope a priority project such as introducing and amending law or regulation in their home country, and we provide follow-up support for alumni and ask them to report back on progress on their projects. Predominantly, this is through support from our regional managers, who are lawyers qualified within their own regions and more familiar with the local context. And I mentioned our team is spread across multiple places. For us, having regional managers who are based in Fiji, Manila and Nairobi, supporting the Pacific, Asia and Africa respectively, is a really crucial element of our program and enriches our approaches to using law for NCD prevention and control and providing appropriate support for alumni. Additionally, another crucial aspect of this success has been having those fantastic partnerships with WHO, the Convention Secretariat and others, particularly in the nomination process and choosing who will come along to our trainings. The WHO has been very useful in supporting that nomination process and helping us to identify who is best placed to apply the lessons of the training, have buy-in for priority projects and have the appropriate role within government. Next slide, thanks. So through this training work and other projects over time, we've built a really strong network of McCabe Centre alumni who are working to use law to address cancer and NCDs in their countries. We've also had follow-up alumni workshops and other online activities, and our alumni from our past trainings contribute to subsequent training programs and also as part of webinars and international fora. And as Professor Kim was mentioning before, that knowledge sharing is a really crucial part of developing this network. Next slide, thanks. So we've celebrated some really great successes of our alumni as they work to develop legal and regulatory frameworks around the world. Alumni from, I think it's now 22 countries, have successfully implemented laws or regulations aimed at NCD prevention. For example, alumni in Malaysia have contributed to laws for smoke-free environments in restaurants, and alumni in Vietnam have contributed to comprehensive alcohol control laws. And alumni in 6 countries have also gone on to successfully defend laws, for example, from legal challenge brought by the tobacco industry. And obviously law reform can be a very slow process. Many of these projects have taken many, many years, and there are many more projects that are in progress, and our alumni continue to work behind the scenes. And we aim to keep providing that support over time and to encourage alumni to keep going with those projects. Next slide, thanks. So I'd like to close with some comments on how we've further adapted our work over time to respond to feedback and other changes we've made, such as the impact of COVID-19. So over the past 18 months, as I mentioned, in-person training hasn't been possible, but virtual learning has created new possibilities for us. For example, our online training program has allowed a much wider degree of geographic spread of participants in our programs, and we've actually been able to have triple the amount of people participating at a much, much lower cost. So that's been brilliant to increase that reach. But at the same time, there's been some drawbacks, such as some of the networking and relationship building has been impacted by only interacting online. So we continue to adapt and change, and we've adapted our programs throughout to address participant needs using both formal and informal feedback methods, such as through the regular check-ins on priority projects. And then last year, we also ran an informal survey for alumni on how their work had been disrupted by COVID-19. And following that survey, we set up a specific 2 webinars in 2 different time zones to address some of the key issues on the impact of COVID-19 that alumni had raised. Many of our alumni, being lawyers in government health departments, had been refocused their work onto the COVID-19 response. So we felt it was really crucial to support that work. Another key adaptation to our course, which we made over the past 18 months, was to include specific information on the links between COVID-19 and NCDs, and also introduce a new unit on universal health coverage and NCDs to better draw connections between these issues and emphasise how progress on universal health coverage and NCDs is a mutually reinforcing approach. And I guess the other key point that we've tried to emphasise over the past 18 months is to make sure that cancer and NCDs remain on the pandemic agenda. COVID-19 makes cancer and NCD prevention and control more important than ever, and law continues to be a crucial tool going forward. At the same time, we've seen industries behind NCD risk factors like tobacco, alcohol and unhealthy foods have seized on the pandemic to push misleading information, such as, for example, that nicotine may limit the spread of COVID-19, or to market themselves as socially responsible and to aim to partner with governments, international agencies and NGOs hoping to influence policy in their favour. As we work to overcome this new challenge, we can't forget our existing public health toolkit and make sure that we double down on prevention and make use of the legal and regulatory tools that we already know about, that we know are really effective, as outlined in the WHO Best Buys. And we also need to adapt to deal with the growing challenges such as the spread of health misinformation, which has been mentioned by a few of the forum participants, has always been an issue in a cancer context, but it's significantly more serious in light of social networks and COVID-19 and the ease of sharing information. So this is something that we're addressing in our work as well. And finally, I've already mentioned how important partnerships are to us, but it's important to keep nourishing those partnerships and collaborations and to find new opportunities to connect and to maintain those key relationships with WHO, various governments, SPC, and that's really, really crucial. So we're excited to be also adapting our training to provide a course focused on building capacity in law and non-communicable disease for civil society advocates. And that's going to be launched next year alongside, together with the Union of International Cancer Control and made available to their members in April.
Hayley,
so
can I ask you? Yep.
Yeah, I'll just wrap up. Okay. So finally, just to reiterate the importance of taking a long-term view. Law reform takes time, this relationship building takes time, and we can't shy away from this and the investment that's required to see real change. At the same time, I think during the course of COVID-19, we've seen laws introduced and changed at speed, which has probably been unprecedented in a public health context for many, many years. So there is a real opportunity to galvanise this time to make sure that effective change is made, but we can't shy away from that investment that's needed and recognise that sometimes it will be a time-consuming process. So we stand ready to continue supporting countries to strengthen their capacity, to develop, pass and enforce public health laws. And we really want to make sure that we can keep fostering those networks for people working on public health laws to share knowledge and build on success. Thanks very much.
Thanks so much, Hayley. So I had made a few notes, and I think you mentioned them all in your closing there. So I would just reinforce the importance of partnerships and networks. That law reform can be a slow process, so we do need to be in it for the long term. We need the kind of continuity that Professor Kim was talking about. And finally, I think both the opportunities and the challenges of moving to online virtual learning, and I guess we'll be transitioning to a time where there'll be more international travel again, and we need to work out the best way to do both in-person training and remote networking and connection in a complementary way. So thank you very much. And now I'll invite Miles Young, Director of Human Rights and Social Development at the Pacific Community.
Thank you very much, Jonathan. First of all, I'd like to congratulate the World Health Organization for organizing this forum on law and COVID-19. And Vinava Levu, thank you very much for the opportunity to contribute to this panel discussion. For those who may not be aware, the Pacific Community, or SPC, is a regional intergovernmental organization. We have 26 members comprising 22 Pacific Island countries and territories, plus what we call our metropolitan members, being Australia, France, New Zealand, and the United States. Our work is to support our 22 Pacific Island countries and territory members with their development priorities through the provision of technical assistance, capacity building in areas like public health, agriculture, land resources, in fisheries, maritime resources, geosciences, climate change and the environment, and the area in which my division leads, human rights, gender equality, social inclusion, and culture. And particularly through our public health division, SPC has worked closely with Pacific Island countries and territories in responding to the COVID-19 pandemic, including in close collaboration with our friends at the WHO and other UN agencies like UN Women and UNICEF. I thought I'd start, I have a slightly different approach to my presentation, and I thought I'd start by mentioning that in the early months of the pandemic, 13 Pacific Island countries declared a state of emergency. They implemented a range of measures to protect their people, prevent the spread of COVID-19. And primarily these were stringent border controls, quarantine requirements, internal travel restrictions, the closure of schools, and social distancing measures. what is interesting is that some of these emergency measures are still in place, some of them close to 18 months after they took effect. And in the context of this forum, which is around looking at strengthening legal responses to health emergency phenomena like COVID-19, I think one of the key questions to consider, at least in the Pacific, is the extent to which the so-called Syracuse principles are incorporated into these international laws in the Pacific, which govern emergency responses. In other words, to what extent are these emergency measures reasonable and proportionate? To what extent do they maintain the respect of human dignity? Are they subject to timely and systematic review? So the question is, to what extent are the Syracuse principles incorporated into national laws in the Pacific? But perhaps more importantly, how are these principles applied? They may be in the law or incorporated into the law, but how are they applied, and how will, and perhaps most importantly, how well do our communities understand and appreciate the principles, especially in relation to the reasonableness of measures and the need for these measures to be subject to timely and systematic review. There's a danger, of course, that restrictive measures of the kind introduced during these unusual times, pandemic times, which are, as we all will concede, are very unprecedented times. The danger is, of course, that they will become accepted by communities as the norm, and I think that's something that we need to be very wary of as we ponder the question which this forum is considering. Now, interestingly, in Fiji, the prosecution of curfew infringements came under the spotlight when a court highlighted that a number of those punished were unable to pay their fines and would disproportionately suffer as a result. I understand that this case is a subject of an appeal, but the other thing to point out is that early on during the pandemic, breaches of curfew resulted in convictions being recorded. The courts are taking a slightly different approach now, 18 months on. But one of the key questions for many of us to consider is the impact on the future of those against whom convictions were recorded for curfew infringements, for example. Some of which may be considered to be relatively minor infringements. What impact will that have on future prospects of employment, migration, if they wish to move on to, if they wish to migrate to other countries, etc., etc. Some of you may be aware that there is a no jab, no policy when it comes to the civil service, and in the private sector, it's a mandatory condition of work. The impact of that is that many people have lost their jobs because they have not been vaccinated. Interestingly, the Ministry of Health and Medical Services has terminated the contracts of 50 plus medical personnel because of this policy or this mandate. Many in the private sector have also been had their employment terminated. Interestingly as well, after the no jab, no job policy was introduced, there was a significant increase in the vaccination rate. So, you had on the one hand an increase in vaccination rate, and then on the other, you had these consequence, this consequence of people losing their jobs because of an unwillingness to be vaccinated. It should be interesting. There is a case which is before the courts, which is challenging this no jab, no job measure, and it'll be interesting to see what the final outcome of that. Just very quickly, I also wanted to just talk to violence against women or domestic violence. The Pacific has some of the highest rates of violence against women and girls in the world. the evidence suggests our rates are close to twice the global average. And in the early months of the pandemic, there was an increased demand for domestic violence support services. In Samoa, for example, helpline calls jumped 150% from the same time the previous year, while in Fiji, the National Domestic Violence Helpline recorded a 500% increase in April than it did just prior to COVID-related measures. So significant increase there. The emerging evidence is that this trend points to women and children being confined for longer periods at home due to job losses, restrictions on movement, and the job losses have led to increased financial pressures on families, which can act as a trigger for family violence. So again, it raises an interesting question around the consequences and impacts of lockdown measures. And clearly, the increase in domestic violence was not an unintended consequence, but clearly it appears to have been. And the third example, or the third point I just wanted to raise quickly, is in relation to access to education. Like in other parts of the world, the widespread closure of schools has impacted school children. Access in the Pacific, access to education during lockdown has been very uneven. There are clearly schools and families with access to the internet and to devices which allow for online education, but a significant portion of our communities do not have access to good internet and to devices, while multi-generational extended families, which is common in this part of the world under the one roof, impacts the ability to learn at home. So those measures around school closures and the restriction of movement has had an impact on education. So I think I wanted to highlight these examples because it comes to my point, which is that the need for any legal response to addressing a health emergency phenomena like COVID-19, I think needs to apply a people-centered approach, or an approach which is informed by a rights-based approach, by gender and social inclusion considerations, by cultural considerations, needs to be considering socio-economic, political considerations as well. And I think, a people-centered approach in any legal response or any legislative framework is not to diminish in any way the health and the technical considerations around health when it comes to something like COVID or any health phenomena, but to marry these health and technical considerations with the considerations which I've just mentioned. So it's a balancing and a marrying of these considerations, not having one take precedent over the other. And of course, as you all know, Secretary General Guterres has been very clear about the need for human rights to be central to any COVID-19 response. I just wanted to very quickly, just looking at the some of the framing questions, I thought I just wanted to, before we move on, just to very quickly touch
can
on.
I give you 2 minutes?
Yes, very quickly. There was a question here. The first question is around how do we better demonstrate the role that the law plays in supporting effective public health emergency preparedness. And what I wanted to quickly mention here is that we often develop and implement legislation, but what is often forgotten is the need to continuously monitor and evaluate. And in this case, any legal response or legislative framework. I mean, laws are passed, frameworks are developed and implemented, but we don't give enough attention to whether they are achieving their objectives. So I just wanted to quickly point in the limited time that I have left to say that consistent monitoring and evaluation is an area which I think more attention is needed, and I think it also allows us to implement real-time pivots to our responses when this is necessary, by referring to the data, by referring to what's happening, because we've got real time information to be able to take those decisions. Thank you, Jonathan. I have taken up too much time already, and hopefully there'll be further time to unpack some of these points.
Yeah, thanks for a great presentation, Miles. So a few things that came out of that for me. So really reinforcing the importance of a rights-based approach, people-centered approach, needing to monitor and evaluate the laws and the implementation. And I think in particular, as you've pointed out, some really serious unintended consequences, increases in violence against women, effects on education. But then also I think a really interesting point about not just the laws, but the norms. So as countries do transition out of this emergency situation, so we need to look at both the laws that we'll be amending and also what norms might have changed over that time, and what we do to then try to move away from some of the norms that might have been appropriate in emergency situations, but really shouldn't be ongoing once we're out of that kind of crisis. So thanks very much for your great presentation. And now we'll turn to Dr. Rohani Jahis, Head of the Zoonoses Control Sector at the Ministry of Health in Malaysia.
Thank you, Mr. Chair. Just share my slide. Assalamualaikum and very good morning, good afternoon, good evening, ladies and gentlemen. Can you see the slide?
Yes, thank you.
Thank you. Okay. So this is the question given to Malaysia. Okay, so basically overview of the legislation in MOH. Actually, we have 28 acts under the purview of MOH for management of COVID pandemic. Actually, there are a few legislation that were used. Basically, one is the Prevention and Control of Infectious Disease Act 1988 to manage case, contacts, and control the spread of disease. And we have the Sale of Drug Acts 1952 and Control of Drugs and Cosmetic Regulation 1984 for managing vaccines and monitoring AAFI for vaccination, COVID vaccination program. So in MOH, all the legal issues are dealt with the advice from the Legal Advice Office, which is under the Director General. We were sort of lucky that prior to COVID-19 pandemic occurrence, Malaysia have undergone a joint external evaluation of IHR core capacities. And one of the scope that was evaluated is related to legislation. So in managing infectious disease crisis or pandemic, beside the Prevention and Control of Infectious Disease Act, the National Security Council Directive number 2020 is used in managing major outbreaks involving multiple districts and states. This directive is under the Office of the Prime Minister, and it's really facilitate the involvement of other ministries and agencies for a comprehensive whole government approach, as mentioned by many speakers before. So for COVID, this National Security Council Directive number 20 was activated. And from the audit, the auditors recommended that we should conduct a holistic assessment of the implementation of national legislation and state legislation, regulations, and other legal documents in a systematic and coordinated manner to ensure they support the government-wide implementation of IHR 2005. So, before we could assess the legal documents, we faced the COVID pandemic, and we take it as an opportunity for us to review the legislation related to infectious disease pandemic as a whole. So as mentioned, the Prevention and Control of Infectious Disease 1988, or we call it as Act 342, covers all 15 states in Malaysia, and it's been used widely for notification and management of 31 infectious diseases. And it was also used in managing Nipah outbreak and H1N1 pandemic without any issues, because those two outbreaks were considered small and the impact to public health was not so great. But however, during the COVID-19 pandemic, it was used extensively, and many SOPs and regulations was made under this act, and it shows how flexible and adaptable the act to the current situation. And during this outbreak also, COVID-19 was made notifiable, mandatory notifiable. So it makes the notifiable diseases to 32. Okay. And in early of this year, when the number of cases, COVID cases escalated here in early of the year, and the health delivery system nearly collapsed, emergency ordinance was enacted, and health emergency was declared in order to support the management of the COVID pandemic. So through this emergency ordinance, there's a provision to obtain support from non-MOH health services providers, basically the university hospitals, private hospital, as well as laboratories. And through this emergency ordinance also, we make the cost for testing affordable and can be obtained by all walks of people. And this ordinance also support the implementation of the acts and regulation to contain the pandemic. Okay. So, as I mentioned earlier, this pandemic is an opportunity for us to assess the Act 342, and I share with you some of the issues noted during the pandemic. Okay. First, we know that the extent of the pandemic is quite great, and we need extra manpower to manage cases as well as to enforce the act. So in order to enforce the act, in the current act, it just mentioned public servant from other ministry or agencies could be appointed as authorized officer. And we found that actually is not enough for us. So we make amendment to the ordinance to include private practitioners and district officers to be as the authorized officer, as to assist MOH in issuing health surveillance order, as well as to manage the cases and contacts in the community to ensure that they abide to the instruction given by the authorized officers. And then number two, we know that during a big massive outbreak, we need to contain the cases and as well as contacts. So we declared all states as local infected areas to facilitate movement, order, control. So it was successfully reduced the number of cases in the first wave. However, there was a thought to declare other countries as infected areas. However, because of economic impact and also G2G relationship, so it was never been declared. But the provision was there in the act. The declaration of infected local areas also assists us in border control activities. Okay, number three, with the as mentioned eloquently by Prof. Wang just now, it is very important to regulate people to abide to the non-pharmaceutical intervention, basically the public health measures. So the DG of Health was given the power to develop SOPs that are binded by law and need to be followed by the community. And it goes the same to the minister, who can make regulations which give us opportunity to control the pandemic better. And another important thing in this current era is the digitalized technology. So with our present act, the surveillance of COVID is done, surveillance of diseases is done manually, meaning they have to submit the notification form or doing the phone call. But then during this COVID-19, we know time is very important. So the digitalized integrated surveillance system was built and it became the source of notification. So we changed from manual to digitalized, and it is made legal by the law. Okay, number 5, that we noticed the order for isolation and observation of COVID cases. In the act, it was mentioned that all the quarantine should be done, all the isolation should be done in quarantine station. And the quarantine station including the hospitals, and it goes for all cases regardless whether they have symptoms or asymptomatic. But when the number of cases were overwhelmed, isolation of cases need to be done at home and with strict enforcement. So then we make amendment to the act through the emergency ordinance to allow cases to be isolated at home and being followed up by the practitioner, either from public or from private setting, to ensure that the patient are healthy throughout the isolation period. And referral were made where if the condition worsened. And another thing is for quarantine as well as isolation, patients are required to wear a tracking device. So this tracking device is to ensure that those are ordered to stay at a set address to be there all the time during the isolation period or quarantine period. So this wearing of tracking device will also put into the emergency ordinance to ensure that we are covered by the legal side of this new provision. Okay. These are a few of the issues that we noted during the management of COVID-19 pandemic until now. There are a few more that are small and I won't share it here because of limited time. So moving forward with all these findings and observation of the legal requirement for better management of infectious disease pandemic in future and part of preparedness, we put up all these provisions into the amendment of the Prevention and Control of Infectious Disease Act to be tabled soon in Parliament to ensure that the continuity of the enforcement of the provisions during the emergency ordinance will be continued once this ordinance is revoked. I think that's all. Thank you.
Thank you very much, Dr. Jahiz, for an excellent presentation. A few really brief comments is, I think you also mentioned the importance of evaluation, as Mild did, and when you spoke about started off with the joint external evaluation. I think we saw the importance of ministries and agencies outside of health, mobilising personnel from those agencies, and the importance of flexibility within our legal frameworks and to be able to respond and adapt quickly as the situation evolves. So thank you very much. And now I'd like to invite Delphina Kerstlake, Assistant Chief Executive Officer, Legal at the Office of the Director General Health in Samoa. Over to you, Delphina.
Tala Falavan, greetings everyone. I see so many familiar faces. Hi, Jonathan, and names, and I'm happy to be part of this forum. So for the topic for today and contribution, so how can we better demonstrate the role that the law plays in supporting effective public health emergency preparedness and response? So COVID-19 has taught us many lessons, and it has made us realize whether there were effective laws in place to deal with the pandemic. And from listening to the various country experiences that have been shared during this forum, we have seen many utilizing different instruments, some emergency powers under their constitutions, public health laws, disaster management laws. And the bottom line that I think we've all realized that having a proper legal framework is paramount. Having an effective legal framework in place for any type of outbreak, diseases, epidemics, or pandemics, of course, will always assist public health emergency and responses. For Samoa's experience, we did use our emergency powers under the Constitution, and as well as one of our very old and ironically relevant public health laws, our Health Ordinance of 1959, which also helped us to legally be able to respond to COVID-19. With this being said, we had just come out of a measles epidemic. So for the climate at the time for us was current, was relevant, and it kind of, we already had a snapshot of what needed to be done to assist in combating COVID. So what are the lessons that we had learned and the attention on the role of law to both support the ongoing COVID-19 response and especially to strengthen legal capacity? And the lessons learned is there should always be a good, solid planning framework that assists all relevant stakeholders to guide them, as well as inform on the limitations and the boundaries on what we can do and what we cannot do. And this can be done, I mean, for us, it's in the form of a national country level plan that deals with pandemics. And further to the plans and the policies, this helps inform the law, which mandates us to act in a legal way to control and combat COVID-19. I know that one thing we have learned, and I've heard from several countries, is that we now all are able to identify the gaps in our laws and have possibly made plans to address those gaps, given the experience of COVID-19. And the importance of laws, a simple example is COVID-19 is spreading internationally. We want to close the borders. Do we have the necessary legal powers to do that? Do we have effective laws to restrict movement? How do we weigh that with fundamental and human rights? Do we have the necessary laws to close down schools and public places in our own jurisdictions? In times of pandemics, law is important because it is the tool or the instrument that people have come to understand, people have come to obey, have faith in, hopefully, and offers guidance as well as control measures on how society can address these type of events. And then there's always, we have to balance the interests of public health versus the individual right. Where do we weigh this? We also, and I know in different countries, have national committees which are led by the main leaders of the country, involving all relevant government and non-government actors and involving civil society and NGOs. And most countries use these legal capacities to address this pandemic, as well as ensuring access to health for everyone. The multi-sectoral approach is important in the context as no one can act in silos in events such as public health emergencies. So how do we use this opportunity to ensure our legal frameworks better protect and promote the health of the marginalized and the hard to reach groups or vulnerable groups during emergencies and at all times? With this pandemic, we have also realized the need to protect whole of society, and the concept of health in all policy, which has been around for the last decade or two, has now become fully realized how it is important that access to health may be obtained by all. In certain communities like Samoa, how did we reach out to the disadvantaged, marginalized, and hard to reach groups? We worked within our cultural context, but that is what works for Samoa. Different countries have different methods. So the involvement of community, the empowerment of local leadership, the principle of collective responsibility, and having proper frameworks to address the needs of these vulnerable groups. So the Pacific Way, the family, operates in a communal way, and that's how the concept of collective responsibility works. And that concept helped us prevent COVID-19 from entering our shores. We're still COVID-19 free. It has helped us for people to access vaccination through vaccine campaigns and drives, and also ensuring access to health facilities. So how do we move forward with this? Well, of course, we need help. We always need assistance, whether that is in financial or technical form from WHO and our development partners. This is where they may assist. Legal capacities need to continue to be developed and to help inform law reform. We have the IHR, the International Health Regulations, which guides countries and member states on how to deal with outbreaks and epidemics and pandemics. And also, most importantly, the notification of diseases is very important because of travel and trade. We also need this to be reflected in our national laws in our own respective jurisdictions so that we are legally able to enact this. So in closing, I know I'm almost last, so I thought I wouldn't be long. We need to continue to build legal capacity for health emergency preparedness and response. I don't think anyone expected COVID-19 to last this long, and who knows how much longer that it will be, but we have to adapt and we have to learn and live with that. We have truly learned what it is like to live in a global pandemic, firsthand experience for many of us. And the words isolate, quarantine, vaccinate, prevention, PPE have become our everyday language. So the important points that I've taken during this experience is multi-sectoral approach. You know, the whole government approach is very important, with including our non-government actors, civil societies and NGOs in our communities are just as important. Good sound policy and legal frameworks, resourcing and financing, because not all countries are at the same level playing field. Others have more resources than others. And this is where also our regional organizations and development partners may assist. And of course, collective responsibility, because this cannot be solved on our own or by a few countries. The approach is global and the remedy is global. And therefore we are all obligated to help one another. And thank you for the opportunity to participate in this forum.
Thanks so much, Delphina. Lovely to see you too. I think some of the main points of this really is an opportunity for us to be identifying those gaps and making plans to address them. I think you really articulated the importance of cultural context. Things are different in different countries, and that what we do needs to really work in our own local setting. That whole new language that we've learned, those words that you mentioned, many of us have not really been familiar with before. That's an opportunity to what do we do with that new language and that learning. And then, as you said, the importance of resourcing and financing our preparedness and response. So thank you, Delphina. So over to our final speaker, Mele Tangivakatini, Government Lawyer, Department of Justice in Nauru. Over to you, Mele. I think you're on mute.
Thank you, Jonathan. Mojeko, and good afternoon to everyone. My name is Mele Tangivakatini. Joining me from Nauru Justice is Wiley Detenamo. We will try and do our presentation within the time allocated given to us. On behalf of the government of Nauru, we would like to give our sincere thanks to the organizers for allowing us to be part of this forum. In my presentation, there will be 6 core issues I will try and discuss. So the first issue would be the role of laws and legal advisors played in the COVID-19 response in Nauru. You will note that from my presentation, it will be specific to Nauru context. The lessons we have learned as well, the capacities that might need to be strengthened in the future, what has worked well for Nauru so far, the challenges we have faced, and also any support that may be required from international agencies, including the World Health Organization. Now, in terms of the COVID-19 for Nauru, I remember late in 2019, when we started receiving news of a new virus, a travel advisory was issued by the Department of Justice to restrict travel from certain countries. This was done as an interim measure by the government, awaiting the decision by the WHO on whether COVID is a pandemic or not. In terms of the laws for Nauru, when COVID-19 hit, we had to go and identify the laws that were already in place that were necessary to ensure that at least we have the legal framework for the purposes of COVID. One of the laws that we still have in place is the Notification of Infectious and Contagious Diseases Ordinance of 1923. The second one is the Sanitary Inspectors Ordinance of 1921. We still have the Quarantine Act of 1908 and the Agricultural Quarantine Act of 1999. So from there, you will note that most of our laws relating to health are quite old, but fortunately for us, we do have a law, which is the National Disaster Risk Management Act of 2016, which enabled us to at least, which is the basis, the legal basis, which allowed us to make laws, further laws relating to COVID-19. So on March 16th of 2020, there was a declaration by the President, who is also the Minister for National Emergency Services. This declaration was not made under the Constitution like most countries. Our declaration of national emergency was made under the National Disaster Risk Management Act of 2016. So this declaration, since it came into effect on 16th March of 2020, it has been extended every 30 days. So once we have our declaration in place, we had to identify, and a decision had to be made to ensure which department should be responsible for the purposes of COVID-19. Though the Department of National Emergency Services under our National Disaster Risk Management Act has the mandate to implement the act. For the purposes of COVID-19, the decision was made from the initial stages that it should be the Department of Health and Medical Services to take the lead in the fight against COVID-19. So after we were able to identify the responsible department, then we had to make additional laws. So from there, we had to, because we did not have any specific law that that allowed us to at least have a legal framework in our fight against COVID. So from the declaration, we managed to have a number of regulations made. So before the regulations were made, a national coronavirus task force was formed. This included members of the different sectors of the government with a strategy to capture and contain at the border. This is so due to Nauru's location, which is in the Central Pacific, and with the closest neighbor being Kiribati, which is about 200 miles to the east, and also on the fact that our population of about 12,000 and a land size of about 21 square kilometers. So you would understand due to these factors, we had to make, the government had to make the decision in terms of the laws that need to be made to ensure that that our people are protected from the COVID-19 virus. In addition, subcommittees were formed as well to assist the task force in its work on specific matters, whether it be health, border, or community issues. Now, on 19th of March of 2020, we had our first COVID regulations. These regulations allows for the management and minimization of the impacts of COVID-19 at the border. This also ensures and enforces the declaration that was issued by the President on the 16th of March of 2020. In terms of these regulations, it required all travelers, whether they be Nauru citizens or foreigners alike, to Nauru to be at a designated residence for 14 days. And this was later reduced to 5 days based on information from WHO. In addition to the first COVID regulations, we made rules as well for the occupants of the designated residence. Now, when we were making these regulations, we identified 3 types of designated residents, which are the transit station, observation station, and the treatment station. The transit station is for screening or testing of COVID-19. Observation station is for anyone who presents any sign or symptom of COVID-19. The treatment station is for treatment and hospitalization of anyone found to have gotten COVID-19. Now, for all these travelers, the government covers the expenses for keeping them in designated residence. This includes food and free Wi-Fi. One of the lessons we learned from the first COVID regulations we made was that additional laws would be required if community transmission occurred. While we have managed to capture and contain the virus at the border, another set of regulations were made to cover community transmission issues. Nauru only has 1 international airport and seaport. We have 12 districts, and like in any other Pacific Island country, most of us live with our extended families. Also, we have a high rate of NCDs like diabetes, and it was important that the legal framework for COVID-19 be reviewed and updated. Apart from the laws, more health officials were recruited from around the region. Now, on 4th of May 2020, we managed to have our community transmission regulations. These regulations supplement the first COVID regulations as well as the declaration of 16 March. With these community transmission regulations, we were able to conduct public awareness with frontliners, public servants, and the community. Several trainings were conducted for the police and health workers to make them understand their legal responsibilities and so forth. With the coming into effect of the community transmission regulations, the task force and with the assistance of other stakeholders, we started having practice community tracing, practice drills of an outbreak from a remand center, the hospital, from a district, and from transit station. This was done through public notices where we issue updates to the public, and also deep briefing were done on lessons learned and areas to improve on are discussed after each practice drills. The community transmission regulations also encourage voluntary action by all citizens and residents alike. In addition to the potential community issues that may arise, we were confronted with another issue. These were the seaport and airport border issues. There was a lot of close contact between the crews of aircraft and vessels, as well as those personnel from the ground, though we have some laws in place relating to customs and immigration. They did not have enough mechanisms for the purposes of COVID-19. In 20th May 2020, we did another regulations, which was the ports regulations, and it was necessary to avoid interference with the loading and offloading of cargo at the airport and seaport. Further, it also provides for the control of embarkation and disembarkation from a vessel or aircraft. It also allows for the screening and examination of crew members, as well as contact tracing on vessels and aircraft. Apart from the ports regulations, we did another regulations, which was the Maritime Security Prohibition Regulations, which came into effect on 1st May of 2020. This was to ensure that and also prevent a person from approaching or boarding any ship in narrow waters, take or cause another person to take any material onto a ship, and also to prevent another person from removing any material from a ship in narrow waters. Furthermore, when the borders were closed in 2020, a number of foreigners were stranded in Nauru. We have flights to Fiji and Brisbane, and when both Fiji and Australia closed their borders, we were basically locked out. The government deemed it necessary to help. This resulted in the making of a COVID-19 visa regulations, which came into effect on 20th May of 2020. This allowed for the issuance of temporary visa to our foreigners to enable them to remain in Nauru until the border restrictions have been relaxed and international travel is allowed. Now, recently on 20th March, we made our vaccination regulations. This enabled vaccination and vaccine usage. In May, we conducted our first vaccination drive, which resulted in the vaccination of around over 7,000 individuals, basically adults, including foreign nationals. This represents...
Can I give you another minute?
Sure, I'll wrap up.
Thank you.
Yes, in terms of the challenges, one of the main challenges for Nauru during this COVID time is shipping and food security. About 90% of our food is imported from Australia, Fiji, and the Solomon Islands. And when a vessel fails the COVID clearance, our food on the island is affected, and also food prices increase. And our future plans is to have a public health bill instead of relying on the National Disaster Act, and also to have a Biosecurity Act. So just to wrap up, government support is key, and we continue to be given such support for the management and minimization of COVID-19. That is all from now.
Thanks so much, Melee. So a couple of thoughts. I think you really illustrated how difficult that balance is between controlling the borders, but also allowing in essential imports, food and other essential supplies. And I thought also you spoke about how important it was to have police, health workers, others trained in the law, and it was great to hear about those the practice drills as an example of training. What we want to do now, it's because it has been a bit hard to discuss in a group of this size. We want to just give a few minutes for people to look at the Padlet and to provide some comments on the Padlet. Alyssa, are you able to share that? So the last I looked, we had one comment on the Padlet, but we'd like to give about 5 minutes for people to add some written comments. Yeah, Alyssa has added put the link into the chat box. So if you click on that and enter the password health law, and you just need to click on a plus sign to be able to add some comments. So we'll leave about 5 minutes and then we'll come back. Alicia, are you able to then put that on put the Padlet up on the screen? Okay, so as we're waiting for some comments to appear on Padlet, did anyone want to ask any questions of the panelists? We'll have a few minutes if people would like to do that. So you're welcome to either raise your hand on Zoom. You could put something in the Zoom chat that I'll be able to see. There's also an invitation for any of the panelists who would like to respond to anything that they heard from the other panelists. Professor Kim.
Yeah, can I ask what is the next step after this forum? Can you make a discussion or? Yeah.
We'll do. Wipro will wrap up in the next session, so we'll definitely get to that. Miles?
Thank you, Jonathan. I had a question for Delphina, but also to all the other panelists. Thank you, Delphina, for your presentation, and thank you to all the other panelists for their presentation. But Delphina, you mentioned culture and the cultural context in your presentation, and to me that's very important. You know, at SPC, our work is very much underpinned by cultural considerations, as I mentioned, but didn't really expand on in my presentation. So I just wanted, and I know in Samoa, you're very, very strong on culture. You know, for our Samoa is very, very strong. I mean, that's not to say that it's not strong across the Pacific, but I just wanted to just unpack that a bit more from you in terms of your cultural, when you were taking into consideration culture, what are some of the things that came up in those discussions or in those considerations?
Okay, thank you, Miles, for the question. Yeah, I think sometimes us that live in the Pacific take culture for granted because it's our everyday life. It's just the way we do things. So if I'm correct, if I understand the question is unpacking a bit on the culture, on helping to address what's going on. Okay. So yes, because it's a set up in the particular societies, in Pacific societies, where you have the local setup in the communities, and also the relationship that the local community has with the government, and also that relationship with civil societies and other NGOs, and all culture, and all these different groups play different roles, and all these roles complement each other. So perhaps I could use an example. We had a 2-day lockdown where everything closed, public and private, to get our vaccination numbers up. And before we went out into the districts, it was a national, we managed to, well, we're a small country, only like 200,000. But on the 2-day national lockdown, we managed to vaccinate 20,000 in 2 days. And that was because of how everyone worked together. So when we went out into the villages through our own cultural context of communication and public relations and all that, everyone was prepared because the local councils had already prepared, and they assisted government on how to carry out that role. And I think it's a lot to do with awareness and education. And once people come to a basic understanding that it's a collective responsibility and it's just the method that we need, it's actually the remedy, or vaccination is actually the answer right now in our world, then they tend to come and comply and also agree with it. So perhaps with our 2-day lockdown, using that cultural context and using the communication with all the different spectrums in society, we were able to do that.
Inaka Delphina, thank you.
Thanks, Miles and Delphina. We've got time for one more comment or question. Anyone from the panel? I see a couple more comments have been added to Padlet, which is great. Okay, should we leave it there? Okay, so thanks everyone for your great presentations. That was a fantastic session, and I know that will really help Wipro as they think about what the next steps will be. So we'll come back in just under 15 minutes at 12:30 Manila time for the final session. Thank you very much, everyone.
Thank you, Vinaka.
Hi everyone, welcome back to our closing session. Just a final reminder for those on Zoom that the event is being live streamed on the Melbourne Law School's YouTube channel, and we're recording the event and we'll be posting it online soon. So I'm going to now hand over to the team in Manila, to both Genevieve House and Ben Lilly from the Health Law and Ethics Unit at Wipro.
Thank you so much, Jonathan, and our enormous gratitude to all of the participants and everybody who has contributed. Sorry, just give us a minute. We're just getting some slides up. Thanks so much. So now wrapping up, myself and Ben Lilly will provide some comments. Next slide, please. So we're looking at experiences and lessons identified, just trying to draw out some themes of the very rich discussions that we've been having over the last 2 days. So some of the things that we have seen, most countries use their national legislation, saw how important it was to support their COVID response. For many, the legislation supporting the public health functions wasn't fit for purpose. Laws supporting basic health functions didn't always align with the health emergency powers, the national disaster laws that were needed as the risk escalated. And there was also an important alignment with across sectors and levels of government. Many countries did enact legislation to fill the gaps, and some of those laws have explicit sunset clauses, and others would be expected to be ongoing. Some public health and emergency laws were outdated. They didn't contemplate a pandemic of the scale of COVID-19 or the response strategies required. So this would include the need for a whole of society collaboration, the use of new technologies, and other purposes. And for many, they're now looking at reviews post-COVID. Next slide, please. Many of the challenges weren't new. The pandemic did reveal and exacerbate long-standing issues, which would include disparities and cracks in the health system. Laws beyond health did affect the response. Some laws, criminal laws, housing laws, laws about public finance, many other laws contributed to the impact on vulnerable people, and in some instances did hamper the efforts to detect cases and deliver COVID-19 related services. In our rush to respond, at times clouded our focus on the health and safety of healthcare workers and the rights of patients, including to culturally appropriate care. Changes in employment arrangements also had an impact. Next slide, please. We also learned that laws supporting data collection and use are of enormous importance. Managing communication was a challenge to most, and the ready availability of data, which is related to inform that communication, was also important, making sure that communities had access to the most recent science-based information, and laws that can support and impede this are relevant. And now I'll hand over to Ben.
Thanks, Genevieve. Next slide, please, Melissa. We heard that trust and effectiveness of digital health interventions are strongly interrelated, and that legal frameworks played an important role in ensuring the digital interventions used in the COVID-19 response were trustworthy, and they exhibited competence, integrity, and data beneficence. We heard that this could have a positive impact on voluntary uptake and acceptance where laws were established and implemented. Where laws were established and implemented. effectively, and particularly where they sought to address perceived risks, such as those associated with mission creep, offshore data storage and secondary use, especially by law enforcement. We heard about some of the barriers to the application of digital health technologies, and those included both limited legal and regulatory frameworks, as well as factors beyond the health system, such as ICT policies and infrastructure. Next slide, please. We heard that the private sector played a significant role, including through the delivery of COVID-19 related services and the provision of medical supplies and vaccines, and that effective engagement helped to leverage their resources and capacities and to align it with national strategies. We also heard that political leadership has been essential to engaging the whole of government and whole of society in the response, and that legal frameworks can play a role in empowering leaders across the community. Next slide, please. So now I'd like to turn to some possible directions for the future and some key points and common themes that we picked up in the conversations. The first is that there's a need to adopt a systems approach to building legal preparedness, and that is to consider, and that includes to consider actions are required to improve public health and health emergency laws, as well as other laws that have an impact on health during emergencies and generally. There's opportunity to take practical steps to identify lessons and share experiences in real time. And that includes to record challenges and issues that may require further legislative change in the future. And there's a need to look to integrate human rights principles within legal frameworks for health emergencies and to build the knowledge and capacity to implement and to have regard to those. Next slide, please. There's a need to examine the legal and regulatory barriers faced by digital health technology during COVID-19 and to leverage our experiences to enable the appropriate effective use of technology for health applications beyond COVID-19. There's a need to explore mechanisms to promote greater multi-sectoral coordination and governance of our response efforts and the health system generally, including in the area of digital health. There's a need to examine the legal dimensions of privacy and public health in light of COVID-19 and recent advancements in technology, as well as to consider measures to protect privacy in line with local needs and expectations. Next slide, please. We need to consider mechanisms to address misinformation, while we also support effective risk communication and the transparent sharing of information with the public. We heard that people most vulnerable to NCDs were also often most vulnerable to COVID-19, and by intensifying legal action to address NCDs, we can also have a benefit for our preparedness for future health emergencies. Next slide, please. We need to continue to support efforts to build the capacity of lawyers and policymakers involved in health law, and that includes through training and partnerships. And we also need to empower champions and build networks of practitioners, researchers, and advocates in our region. And that includes connecting with those working in the various subfields of health law, which is still very much an emerging field. Next slide, please. Oh. Actually, sorry, that was the final slide. So look, thanks again for all of your participation over the past 2 days and your contributions to the discussions. As was mentioned at the start of today's session, your contributions will be used to inform a meeting report being developed by WHO which will be published. And it will also inform our thinking for how we can better support our member states and to work with our partners in the region to strengthen legal preparedness for the future. So thanks once again, and with that, I'll pass back to Jonathan.
Thanks so much, Ben and Genevieve. It's now my great pleasure to invite David Manning to give a keynote address. David Manning is Commissioner of Police and Controller of the National Pandemic Response in Papua New Guinea. So over to you, Mr. Manning. I think you're still on mute. Can't hear you.
Now
I can hear you. Go ahead.
Thanks, Jonathan. Well, thank you. Distinguished colleagues, good morning or good afternoon, as the case may be. It is indeed my great pleasure to provide a keynote address for this regional forum on law and COVID-19. Firstly, I'd like to begin by thanking each of the participants in this forum, whose wisdom and practical experience will guide our region in ensuring we have the laws and capacities we need to protect public health and to manage health risk in the future. I'd also like to thank the World Health Organization Regional Office for the Western Pacific for organizing this important event, which I've been informed is the first of its kind in our region, as well as our host, of course, the University of Melbourne. In Papua New Guinea, as with everywhere else, when we first heard about the emergence of a novel coronavirus in early 2020, we did not have the experience of a global pandemic of this scale. We had to work out how to manage as we went along. I'm sure this was very much the case for our neighbors. Before it reached PNG, we started our preparations, including looking at how our laws could help. We began with what we had. We had a 1953 Quarantine Act and a 1973 Public Health Act. Mind you, both pieces of legislation predated our independence, and both were likely to be inconsistent with our Constitution, which came in 1975. Neither was fit to support a coordinated long-term response. Our Minister for Health began to issue orders under those laws, but there was some confusion about their scope and about how to include other important sectors such as immigration, foreign affairs, customs, police, finance, and others. When PNG confirmed the first local infections, including community transmission, a state of emergency was declared and temporary laws were made using available constitutional powers. That was when we first set up the National Control Centre, and I, as the Commissioner of Police, was appointed as the controller. Our National Executive Council recognised the need for a whole-of-government approach with clear leadership, which is why it formed the National Control Centre. I worked with the Department of Health and with other sectors which were represented in the NCC. I was able to use powers to issue directions and to take action for PNG's pandemic response. And as the pandemic has escalated and hotspots and risks evolved, we were constantly issuing notices and taking action under our available powers to try to manage the risk and respond to it. We had to understand each other and work together, which was sometimes hard. We faced many challenges, such as shortages of testing reagents, PPE, and available personnel. And of course, managing effective communication with our people and correcting misinformation. We needed to work with other parts of government and with our people. Sometimes they were frightened. They looked for leadership and for answers. Now, in Papua New Guinea, we love to talk about where we're from, our province, our home village, our wantoks. The pandemic doesn't care which province or village you're from. It crossed global borders to enter PNG and all domestic borders within PNG. It has affected all provinces and all communities and every man, woman, and child in our country. Sometimes it was hard to bring everyone together. We had to keep moving fast and changing our approach fast to try to keep up with the pandemic. As Police Commissioner, I'm always aware of the importance of law. In working in the NCC, it was our constant companion. It was not always a helpful one or a kind one. As the state of the emergency expired, the National Parliament passed another law called the National Pandemic Act of 2020. Its purpose was to keep the NCC going and give us the authority and power to continue to manage the pandemic response overseen by responsible ministers and the NEC. This law was always intended to be temporary and to get us through the immediate need to respond to COVID. We shouldn't expect the next health emergency to look like COVID-19. Papua New Guinea and the rest of our region faces new and emerging health threats, such as those associated with climate change and antimicrobial resistance. To be better prepared for the future, we need to strengthen our legal preparedness for all hazards and commit to ongoing efforts to continually improving them over time as we build back better. The last 18 months have been deeply challenging time for all of us, both in our professional capacities and as individuals. Everyone has lost someone close to them in this pandemic. It has brought out both the best and worst in people. It has stretched our organizations beyond what they thought they were capable of withstanding and shown their fracture lines clearly. PNG was the first country to have our own pandemic legislation, empowering myself as delegated controller to have complete oversight and accountability of a joint agency response under the organizational umbrella termed the National Control Center, or the NCC. The NCC evolved from two tangents: the need for cross-agency cooperation and the government's complete lack of faith in our National Department of Health. Prior to COVID, as Police Commissioner, I was aware of the regular scandals involving the department, corruption in drug supply purchases, continual outbreaks of preventable diseases, staff protests, and woefully dangerous immunization rates, just to name a few. However, I was not prepared for what I found to be the true nature of the health sector. In short, at the national level, the Department of Health has become little more than a shell that is managed by a cabal of multilateral agencies and INGOs. It is these organizations that manage the day-to-day direction of the department. Officers look to them to write their emails, to send them on trips, to write their plans, to do pretty much everything for them. The budget is managed by them. In the early stages of the pandemic, the world, through multiple donor partners, was very generous to PNG in terms of financial support. Our problem was that most of this money was intercepted by these parties using NDOH as a rubber stamp. While we were trying to run contact tracing at the NCC with volunteers, millions of dollars were given to NGOs to do the same job without informing us in the NCC. They undermined our data systems. They disobeyed my directions to set up parallel systems and advised the struggling disease surveillance team accordingly. And these systems clearly did not work. The country was told we were not having outbreaks and that our caseload was low, when in truth, it was 10 times as bad. We also confused our clinics by introducing new definitions and jargon of what suspect cases were called: SARI, or serious acute respiratory illness, and ILI. Subsequently, we have only investigated about 2.5% of the flu and pneumonia illnesses. Why and how could they do this? We're investigating this, but I can assure you it will not happen again. Embarrassingly, we are now at 1.5% national vaccination rate. This, as I said, is an embarrassment. We've had WHO or UNICEF lead on the risk communications to address vaccine hesitancy, not the National Department of Health. The funding given for use for educating people have since dried up, and half the country still does not even know where there is a vaccine available. Against the direction of the Prime Minister, we are managing this on little bits of green cards, which pass as a vaccination card. They can now be bought at the local markets. PNG definitely has a long way to go. As a country, we've taken responsibility for allowing our health sector to become parasitized by individuals and organizations that do not have our people at heart. This crisis cannot be put to waste. We will build back the health sector into something the whole country can be proud of. I'm unapologetic for these words. If these words upset some of you in the audience, however, I doubt that our experiences are unique in our region. Perhaps my experience will provide liberty to speak up. In the end, I'm accountable to the government of Papua New Guinea. Thousands, probably tens of thousands of people have died or will die that could have been avoided had this state of affairs not been allowed to develop. We have a duty to the survivors that is not enabled to continue. As I listen to other delegates, I can see that many experiences and challenges were shared across the region. Learning from each other, important lessons, and is important. Many of us discovered that our legislation did not serve us well in a health emergency. I hope that as PNG looks at its law reform needs post-COVID, a new understanding of common regional experiences and challenges can help us and teach us. We also have experience to offer and to share with other countries in our region. Finally, I'd like to thank WHO for bringing us all together over the last 2 days to help us to understand that we have neighbors and friends who have similar experiences and challenges and are ready to support us, learn from us, or even just remind us that we don't stand alone. Thank you and God bless you all.
Thank you very much, Commissioner Manning, for sharing your experiences, some of the challenges and some of the lessons that you've learned over the period. Thank you. I'm going to, in a moment, invite Martin Taylor from Wipro to close. Just before I do, can I thank you all for your participation in what's been a fantastic event. Thanks to Wipro for the collaboration, in particular to Ben, Alyssa, and Genevieve. And I also want to give a big thanks to Catherine Taylor from the Asian Law Centre at Melbourne Law School, who's made everything work seamlessly at on the university's end. So thank you very much, everyone. And over to Martin Taylor, Director of Health Systems and Services Division at WHO Wipro.
Thank you very much, Jonathan. And thank you for all of your wonderful moderation to take us through these last few days. And it's a real honor actually to speak immediately after Commissioner Manning, who spoke so eloquently and honestly of some of the challenges faced in Papua New Guinea. I thank you, Commissioner Manning, for sharing those experiences with us. On behalf of WHO in the Western Pacific region, I'd like to thank everybody who has joined in the last few days and express my gratitude to those of you who have contributed as panelists, as discussants, and also have shared in the Padlet and the chat. And of course, I'd particularly like to thank our hosts, the University of Melbourne, Jonathan, and all of your team who have lent your experience in hosting virtual events and your technical expertise to make this forum such a successful event. This forum has brought together researchers, practitioners, and country-based colleagues, many of whom who are currently working to review and reform health laws, and some capturing the lessons and experiences and considering where further review is necessary. We've also heard from researchers and practitioners whose work can illuminate and inform our practice. It's of course always harder to connect in a virtual format, but despite these challenges, we've found a big sense of shared experience and understanding coming through in these discussions. I think that's very, very clear, both in terms of the legal issues encountered and the challenges faced. And as some speakers have noted, some of these were well known as COVID emerged and some were new. COVID had a way of exposing many systems cracks, that existed already, and these included weaknesses in our legal preparedness, both our existing laws and also the capacity to quickly and effectively implement them. Many country colleagues told us about their experience applying their laws and the limitations they faced. As they told us their stories, they also asked questions, asking how others managed similar conundrums. What was almost universal, I thought, was that as public health risk escalated from a small risk to a bigger and bigger risk, and then into a health emergency, and from there into a national and international emergency, few laws were able to keep up. It was hard to track available powers, and be clear about leadership responsibility as powers under different laws were triggered. Every country was different, but we heard about gaps in lines of authority, concerns about limitations on powers, about accountability in deploying broad powers limiting people's movements and affecting their lives and livelihoods. We also heard about the need to provide broad powers, but to balance them with accountability, oversight, and respect for the rule of law. We heard a lot about the importance of trust in governments and authorities in the uptake in use of digital technologies and acceptance of health measures generally. We heard about problems faced by frontline health workers and the amplification of systems cracks, and where laws which protect rights have a huge role to play. We also discussed laws about the health sector that affect health and the importance, we discussed laws beyond the health sector that affect health and the importance of considering the broader legal determinants of health in order to strengthen legal preparedness. We were told about how important it was to engage the whole health system, which includes the private sector. And we were also reminded that legal preparedness isn't just a matter of what laws are on the books, but also the capacity to effectively utilize those laws across government and society and to adapt and make necessary changes in response to new challenges. Public health practitioners have always known that laws matter. Those who undertake surveillance and contact tracing, those who work with infectious disease lists and notifications to manage epidemiology and everyday management of health risks, rely on powers to support their day-to-day activity. Those who investigate complaints about rotten food at markets or an outbreak of measles in a primary school. That interest in health law is not always shared more broadly across sectors and leadership groups, but COVID has changed that. That understanding, once tightly held, broke out of its small group of practitioners and officers to include every sector and every person with a leadership role. This certainly adds complexity, but it provides an opportunity too. Our deliberations over the past 2 days have expanded our understanding that whatever our own country experienced during COVID-19, and however adequate or inadequate our laws were found to be, when we told our stories, they resonated with others. It was enormously useful to hear about research and other work to develop knowledge products which are very closely informed by what our country colleagues are telling us are needed. We will carefully tease out these themes as we draft our meeting report. We will also use our new understanding to inform our work with the broader WIPRO priorities for the future document, which sets out several themes, all of which were touched on in the past few days. Those themes are health security, NCDs and aging, the health impacts of climate change and environmental changes, and reaching the unreached. We all benefit from a new perspective, which comes from listening to the experiences and work of others. For WHO, it will inform our work within our region and with our country offices and member states. We also look forward to continue to connect, to build on shared experience and shared challenges, and to grasp the momentum COVID-19 has given to re-examining health laws and laws affecting health. We look forward to continue our work with many of the people on this webinar to support member states across our region to make sure that they have the health laws that they need for the future. So thank you all for your participation. Thank you to the University of Melbourne again for hosting this event with us. And I hope you have all enjoyed it and found it as stimulating as I have, and wish you all a very good rest of the day. Back over to you, Jonathan.
I think that's it. I think you have the last word. So Thank you very much, Martin. Yeah, Wipro will be in touch with the meeting report, next steps, and we'll also be in touch when we post the edited version of the forum on the university's website. So thanks again, everyone.
Bye.